Committee will come to order without objection. The chair is authorized to declare a recess at any time pursuant to Committee Rule 2, House Rule 11, Clause 2. The chairman may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. I now recognize the gentleman from Missouri, Mr. Onder, to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank the gentleman. Before we move to today's business, I'm sure most members and staff and guests have heard that we lost a good friend and a member, Mr. Conley, the ranking member on the Oversight Committee, a guy that both the ranking member and I have had the opportunity to serve with for a number of years. A good man, devoted public servant, longtime local government office holder, and then, of course, a friend and a colleague who fought the good fight here in the United States Congress, and so he will be missed by certainly our friends on the Democrat side, but those of us on the Republicans. Just talking with Ranking Member Raskin, Mr. Conley was a worthy opponent, a worthy adversary, a good man, and we're all saddened by his loss and are thinking and praying for his family. And I would yield time to the ranking member if he would like to say something about our colleague.
Thank you, Mr. Chairman, for those warm thoughts about Jerry Conley. It's a very tough pill for us to swallow. He was a wonderful friend to many of us, a very feisty, tough, funny guy, and he loved this institution very much, and he loved his district in Virginia and the people of Virginia, and he never lost his South Boston accent, and he was a playful guy, and it won't be quite the same without Jerry Conley around here. So thank you, Mr. Chairman.
Thank you. Maybe, I'm sure we're going to do this on the floor today, but maybe because even though he was oversight, he was close to this committee as well. Maybe let's just all stand in for a brief moment of silence in remembrance of Mr. Conley. Thank you. Pursuant to notice, I call up H.R. 1163, the Prove It Act of 2025, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 1163.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Virginia, Mr. Klein, for an opening statement.
Thank you, Mr. Chairman. H.R. 1163, the Prove It Act of 2025, will help small businesses around the country comply with the overwhelming weight of federal regulation. This bill is an important piece of legislation and should not be controversial. It's intended to ensure that agencies comply with existing law and better account for how the regulations may affect small businesses. Small businesses around the country are struggling to comply with the onslaught of new regulations that are enacted each year by federal agencies. Many small business owners are their own compliance officers. They often don't have the resources to hire lawyers and compliance professionals to help them stay on the right side of the law. Many regulations have a significant economic impact on small businesses, which result in higher prices at the cash register and higher inflation. In some cases, small businesses never open their doors in the first place because of a mountain of regulation. And this harms all Americans through reduced competition and innovation in our economy. This is especially true when agencies enact poorly designed, one-size-fits-all rules. When small businesses must comply with such rules, it doesn't just hurt their bottom line, it also means the American people pay higher prices. Under the Regulatory Flexibility Act, agencies are supposed to take small business into consideration when crafting regulations. All too often, though, agencies do not comply with the RFA's mandates. One report found that in 75% of rulemakings, the agencies either ignored costs on small businesses or underestimated the regulation's costs. That is unacceptable. Regardless of whether some believe that the U.S. economy would be better with more or less regulation, we should all be in favor of well-crafted regulation. We should also agree that when Congress passes a law requiring an agency to complete a task, the agency should complete that task. It's not that hard. H.R. 1163, the Prove It Act of 2025, would help ensure agencies more carefully craft the regulations as the law requires. It allows small businesses to petition the Small Business Administration to investigate whether an agency performed the analysis the RFA requires, and it also creates a penalty for agencies that fail to comply. Mr. Chairman, Congress passed the RFA over 40 years ago, yet federal agencies still fail to account for the effects of their regulations on small businesses. The Prove It Act of 2025 is certainly necessary, and I urge my colleagues to support it, and I yield back.
Gentleman yields back. The ranking member, Mr. Raskin, is recognized for an opening statement.
Mr. Chairman, thank you very much. I want to thank Mr. Klein for the initiative he's taken with the Prove It Act. It may be sleep deprivation on my part, Mr. Chairman, but it seems like a kind of whimsical idea to me. Right now, we've got the Regulatory Flexibility Act, which, as I understand it, means that that parties to a regulatory notice and comment period and filings and so on have to already do the analysis of what the potential effect is on small business. And this was adopted back in 1980, and I think it's been working really well. Now, as I understand the gentleman's bill, the objective is to further support small businesses by requiring that every rule that the government proposes in every agency and department must go through one small office in the Small Business Administration. And again, we've been up most of the night in the Rules Committee, so I might be reading it wrongly, but it seems to me that the chief counsel of the Small Business Administration would suddenly achieve a kind of veto power over every rule proposed by every agency in the federal government, whether we're talking about the Nuclear Regulatory Commission, the EPA, the Securities and Exchange Commission, the Federal Election Commission, and so on. So, and if we were going to do that, I'm not sure this is the office we would choose necessarily, the office of the chief counsel of the SBA. The Senate has not even bothered to confirm a chief counsel of the SBA in a decade. I'm not quite sure about the logic of this. The Regulatory Flexibility Act already introduces the substantive consideration of how regulations are going to affect small business, but this seems to be giving them almost like a veto power over it. And the logic of that would be, well, then, the EPA should have veto power to examine the environmental consequences, and then, we've got to give it to the Securities and Exchange Commission to make sure that it's consistent with business, big business interests and so on. And so I think that segments and chops up the regulatory process. It's not necessary to do that, and certainly we haven't shown the necessity of it. And I guess I would just say finally that this administration has sworn its opposition to regulations. I think they're saying they're going to either get rid of 4 regulations for every 1 new regulation, or maybe get rid of 1 regulation for every 4 new regulations. I can't remember which way. But in any event, they're already working to chop down regulations, and so this would be a time to see how that goes without altering the entire the APA process. So, thank you, and I yield back.
Gentleman yields back. Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from Virginia for the purpose of offering an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purpose of amendment. The chair recognizes the gentleman from Virginia to explain the amendment.
Thank you, Mr. Chairman. This amendment strikes "of 2025" from the title of the bill. The change is not intended in any way to alter the important purpose of the bill. I urge support for the amendment and yield back.
Gentleman yields back. Who seeks recognition? The gentleman from New York is recognized.
I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, the Prove It Act is yet another example of Republicans pretending to care about small businesses while actually furthering the interest of big corporations. This legislation represents the latest effort by Republicans to dismantle the regulatory process, giving the biggest companies a powerful new cudgel to wield against regulations and causing harm to the very small entities it purports to help. Our regulatory agencies are responsible for writing rules that protect our communities from harm. They make sure that the toys our children play with are safe. They make sure that the vehicles we drive and the buildings we live in are up to code. They make sure that the legislation we pass in Congress, tackling issues like climate change and public health, are implemented as we intend. But the Prove It Act would grind all of this to a halt. If this legislation is enacted, every single rule, past, present, and future, would be funneled for review through a single official in a chronically underfunded office within the Small Business Administration. Any group that merely purports to represent small businesses could petition this one official to block a pending rule they don't like, and there would be no limit to how many times they could do this. Rules that would ban toxic chemicals or take contaminated food out of the market would hang in limbo, while petitions mount before this single official to complete their reviews, if they can ever complete them all. And who would be charged with this awesome responsibility over a regulatory system? It's unclear, since the SBA has not even filled this position since 2017. But President Trump has nominated someone to fill the post, someone who has questioned limits on polluters, rules that prevent insurance companies from discriminating against people with pre-existing conditions, and the value of sick leave. Because of these views, the nominee was opposed by every Democratic member of the Senate Small Business Committee, and I hope he will be rejected by the full Senate. And in addition to charging the Chief Counsel with reviewing petitions related to new rules, the bill also charges him with tracking agencies' completion of a mandatory review of existing rules every 10 years. If they find that an agency failed to conduct a required review of a rule, they can simply suspend operation of the rule. This is a recipe for chaos and dysfunction. And that, of course, is the point. And with the Trump nominee at the helm, scores of rules that businesses oppose, but that ensure we are safe, could be on the chopping block. Republicans do not want to empower the agencies that ensure the drugs we take are safe, that ensure child car seats protect the most vulnerable among us, and that enforce our competition laws to ensure that small businesses have a chance to thrive. They want to throw sand in the gears of these agencies to ensure that they never issue the regulations we depend on to keep us safe. This bill will do little to help small businesses, but for powerful companies and special interests, it could prove to be a windfall. I urge my colleagues to join me in opposing this bill. And
Will the gentleman yield for 1 second?
I yield to the gentleman.
Thank you very much, Mr. Nadler. And the mystery behind this bill is clearing itself up a little bit in my mind. Apparently, the gentleman that you spoke of who was nominated to be chief counsel of the SBA is a well-known anti-regulatory ideologue who has written advancing his theory that America essentially took a wrong turn with the New Deal in the Roosevelt administration. He opposes the minimum wage. He opposes fines for polluters. He opposes sick leave for employees, mandatory sick leave. He believes Congress should repeal the ACA and certainly undo protections for patients with pre-existing conditions. He blamed the 2008 mortgage crisis on unemployment insurance and so on. So he seems like he's got a touch of Ayn Rand in him. But I certainly wouldn't want to turn the whole Administrative Procedure Act over to this one guy. And I thank you for yielding.
Reclaiming my time, I certainly agree with that, and point out that under this, he could reject the rule, and if the rule is repromulgated, reject it again and again and again, and you set up, what this bill does is set up a minor official as the total dictator over every government agency, an unreviewable dictatorship, unreviewable discretion with all of our lives and safety. It's a terrible idea, and I urge my colleagues to oppose the bill, and I yield back.
Gentleman yields back. The gentleman from Virginia is recognized.
Thank you, Mr. Chairman. Move to strike last word.
Gentleman is recognized.
I would argue that the claim that the Prove It Act gives the SBA too much power is a misguided one. For starters, the Prove It Act does not authorize the SBA to review the substantive policy of any regulation. Instead, it's designed to ensure that agencies are complying with the RFA when crafting those regulations. The only power it gives the SBA is to determine whether the agency has complied with existing law. And if the agency has complied with the RFA, then the regulation will apply to small businesses as normal. But if it hasn't complied with what Congress requires, I thought that's what we were all interested in right now, is ensuring that when Congress passes a law, that it is followed by whatever agency it is directed at. But if the agency hasn't complied with what Congress requires, then the agency will need to show its work. It's not complicated, and the SBA will not be authorized to determine whether the regulation should go into effect on policy grounds. So I would just respond to that and hope my colleagues will support the bill.
Gentleman yields back. Seeks recognition. Question occurs on adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chairs, the ayes have it, and the amendment in nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members, the ranking member requests a recorded vote. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Van Drew?
Where's everyone?
Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Knott votes aye. Mr. Harris? Mr. Onder? Mr. Schmidt? Mr. Gill? Mr. Baumgardner? Mr. Raskin? Mr. Raskin votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Mr. Gooden votes yes. Mr. McClintock votes aye. Mr. Garcia, you're not recorded. Mr. Garcia votes no. Mr. Johnson, you're not recorded. Mr. Johnson votes no. Mr. Cohen, you're not recorded. Mr. Cohen votes no. Mr. Swalwell, you're not recorded. Goldman. Mr. Goldman votes no.
Yes.
Mr. Issa votes yes. Ms. Kamlager-Dove, you are not recorded. Ms. Kamlager-Dove votes no. Mr. Harris, you're not recorded. Mr. Harris votes yes. Mr. Onder, you're not recorded. Mr. Onder votes yes. Mr. Nels votes yes. Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye.
Clerk will report. Gentlelady from Wyoming.
Ms. Hageman votes yes. 14-12, 14-12. Mr. Chairman, there are 14 ayes and 12 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 1605, the Separation of Powers Restoration Act of 2025 for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 1605.
Without objection, the bill will be considered as read and open for amendment at any point. The chair recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for an opening statement.
Thank you, Mr. Chairman. The Constitution deliberately separates the powers of the federal government in a system of checks and balances. Article 1, Section 1 vests all legislative power in Congress, while executive power belongs to the president and the judicial power rests with the courts. This foundational structure ensures that no single branch dominates the other, safeguarding individual liberty from government overreach. But for decades, the executive branch has taken legislative power by issuing regulations that carry the force of law. In 1984, the Supreme Court ruled in Chevron that courts must defer to an agency's interpretation of an ambiguous statute. rather than exercising independent judgment to determine what Congress actually meant. The deference allowed unelected bureaucrats to wield immense legislative and judicial power and issue sweeping regulations with little accountability. In 2023 alone, unelected bureaucrats finalized over 3,000 rules. By contrast, during the same period, Congress passed less than 70 laws. This means the executive branch agencies impose more than 44 times as many mandates as the actual legislators. The consolidation of power within the executive branch directly contradicts our constitutional framework and harms American liberty. It is certainly not what our founders intended. And the regulatory state is not just oppressive, it's costly. According to the Competitive Enterprise Institute, the total annual cost of the federal regulation is now $2.1 trillion, equivalent to over 7.5% of U.S. GDP. If members of this chamber impose that kind of cost on taxpayers each year, we'd be voted out of office. Fortunately, the Supreme Court has finally restored the judiciary's constitutional role in interpreting the law. In a 2024 case known as Loper-Bright, the court explicitly overturned Chevron. The Supreme Court held that under the Administrative Procedure Act, courts must exercise independent judgment while reviewing whether an agency has acted within its statutory authority. As Chief Justice Roberts, quoting Alexander Hamilton's Federalist No. 78, wrote in the majority opinion, the framers, quote, envisioned that the final interpretation of the laws would be proper and peculiar province of the courts. He went on to note that the Administrative Procedure Act, quote, incorporates a traditional understanding of the judicial function under which courts must exercise independent judgment in determining the meaning of statutory provisions, end quote. In other words, the Supreme Court has now recognized what we in Congress have long understood. Chevron was an abdication of judicial responsibility that allowed agencies to run roughshod over both the Constitution and the will of the people's representatives. But while Loper-Bright is a major step in the right direction, it does not resolve all questions of judicial deference. The court left open the question of whether other deference doctrines should be overturned. And courts may very well find ways to invent new deferences doctrines if we do not stop them from doing so. That is why it remains imperative that Congress act to solidify the judiciary's duty to review agency action and ensure that the executive branch cannot continue to legislate outside clear congressional direction. That is why we must pass H.R. 1605. Separation of Powers Restoration Act would formally codify the Supreme Court's decision in Loper-Bright and invalidate any other precedents that require courts to defer to agency positions. This will ensure that courts independently consider what Congress has said through its statutes rather than putting a thumb on the scale in favor of the federal agencies. By requiring courts to apply de novo review, this legislation would ensure that judges exercise their constitutional duty to interpret the law independently, rather than deferring to the very agencies whose authority they are supposed to scrutinize. I urge my colleagues to support this critical legislation and restore the balance of the power demanded by our Constitution, and I yield back.
Gentleman yields back. The ranking member is now recognized for an opening statement.
Thank you very much, Mr. Chairman. Administrative rules take on different political meanings at different points in history, depending on who's in office, who has more power in the courts. And the history of the Chevron in Loper-Bright is fascinating, especially in light of Mr. Fitzgerald's very interesting remarks there. I'm old enough now to remember when Chevron was decided. I was in law school at the time in 1984. And at that point, when it came down, Chevron was considered the conservatives' doctrine. It's what Ronald Reagan wanted. It's what the conservative judges on the Rehnquist Court and the Berger Court had been fighting for. The liberals basically were saying we've got great regulations and rules that have been put in since the Great Society on clean air and clean water, and we don't need a new doctrine. But the conservatives on the court introduced the Chevron doctrine because the liberals wanted to stick with a particular regulation which determined that the word point in pollution had a fixed meaning, whereas the conservatives were saying, no, the EPA, now under Reagan appointees' control, can rearrange the meaning of the word point and have point applied to the entire factory rather than one particular point of discharge. So it was the conservatives then who had advocated the Chevron doctrine and embraced it and were cheering the development of this great new flexibility notion because it allowed the Reagan appointees at the agencies and commissions to reverse rulings that had been in place for a long time. All the liberal environmental and labor lawyers were going to court saying, no, this is what the statute has meant or the way it's been interpreted for 20, 30 years. But now the conservative court in the hands of the Chevron doctrine said, no, it should be, it's a flexible test, and as long, if there's inscrutability or indeterminacy in the language, then we're going to defer to the agency's own interpretation. All right, so I was always very skeptical of the Chevron notion for the reason that the Supreme Court enunciated in the Loper-Bright decision, which is that it's up to the courts to say what the law is. And that goes back to Marbury v. Madison in 1803. It's emphatically the province and the duty of the judicial department to say what the law is. And the agency's role is to be part of the implementation process, but any final authoritative construction of the meaning of the statutory language must rest with the judiciary. So times change, of course. So now we're in a period where the conservatives hate the Chevron doctrine, and the liberals who had originally denounced it now, have been standing with it. All of which goes to show that a neutral rule can take on a very different meaning depending on who's occupying this or that office. I was about to call you, Mr. Chairman, to say, shouldn't we go ahead and say what the vote is? Everybody has voted. We were waiting for more people. But the rule is it's up to the chair to decide when to close the balloting. That's going to help you guys sometimes when you're sitting in that chair. And maybe if I ever get to sit in that chair, it would help us, all right? So you don't know which way an administrative rule is going to cut. Given that, I've always felt you should try to decide it on the merits as much as possible, what you think it is. And I've always felt that the position just enunciated by the Supreme Court is the right decision in terms of interpreting what the law is. So I like the Loper-Bright decision, and I like a lot of what's in this bill. However, I've been working with the chairman to see if we can come around. The part of the bill that I don't like deals with the statute of limitations. So the compromise that we came close to, but in the final analysis it didn't work, it would have scrambled certainly partisan and doctrinal lines. The compromise would have codified the new post-Chevron world, making clear that courts should review agency actions de novo and exercise their own independent judgment in deciding whether an agency has in fact acted within statutory authority. It also would have enshrined certain guardrails, explicitly instructing courts to continue applying stare decisis, as well as continuing to give respect to executive branch interpretations, particularly when based on specialized experience. These are the so-called Skidmore factors. But what's more, the compromise would have overturned the Supreme Court's ruling in the Corner Post decision, which broke with decades of precedent and would have made clear that facial challenges to rules and agency actions must be made within 8 years of the promulgation of the rule. This language, built on my colleague Mr. Nadler's Corner Post Reversal Act, would have avoided the free-for-all that exists when federal rules are in a perpetual state of limbo where litigants can challenge them even if they've been in place for 20 years or 30 years or 40 years. There's no stability for anybody in that, and that just undermines rule of law values. So, unfortunately, at the 11th hour, I believe some of our GOP colleagues walked away from what I was hoping would be a big compromise that we could all live with. In other words, Loper-Bright, which is the law of the land right now, would be codified, but we would not allow rules to be perpetually challenged. which would introduce a lot of instability into the law. So that bipartisan deal collapsed, my preference would have been today to vote on that bill that we were discussing, to the extent that my colleagues are intent on putting up this other version of the bill, which allows for perpetual challenge, I cannot go along with that, and I would have to vote against that. But if it passes the committee, I do hope, Mr. Chairman, that you know I'm sincere about this. I hope we can continue to work together to improve the bill and find real common ground as it moves through the legislative process. It's a good opportunity for us to act in the true spirit of bipartisan compromise and common sense. And I think it would demonstrably improve the bill because, yeah, you can always bring a constitutional challenge, but I don't think an arbitrary, capricious challenge, an ultra-virus challenge should last forever. I don't think people should be bringing those 20 or 30 or 40 years later. So I hope we can continue to work on it, but otherwise I'm not quite there yet. And thank you for your patience, and I yield back to you.
Gentleman yields back. Chair recognizes the gentleman from Wisconsin to offer an amendment in the nature of substitute.
Thank you, Mr. Chairman. I do have an amendment at the desk.
Clerk will report.
Amendment in the nature of a substitute to H.R. 1.
Objection, the amendment in the nature of substitute will be considered as read and shall be considered as base text for the purpose of amendment. Chair recognizes the gentleman from Wisconsin to explain the amendment.
Yeah, this amendment adds interpretive rules, general statements of policy, and all other agency guidance documents to the scope of the bill. These were included in the version of the bill that passed the House last Congress, and I would urge support for this amendment, and I yield back.
Gentleman yields back. The chair would claim some time for a question to the sponsor of the bill. Is there anything in the current legislation that talks about statute of limitations?
Chairman, there is not, which when the ranking member discussed this, and I think the negotiations that were happening behind the scenes, that would lend me to believe why not pass this bill today, and then if we want to come back and talk about a statute of limitations later, that seems like it might be more productive.
Yeah. And that's where I'm inclined to go, and we have had discussions with the ranking member and our staff and their staff, and we'll continue to do that, see if we can find some common ground. But there's nothing in this legislation that addresses or deals with the statute of limitations. Who seeks recognition? The gentlelady from Washington is recognized.
Thank you, Mr. Chairman. I moved to strike the last word. I think I was recognized. I just want to agree with our brilliant ranking member that he's pointing out the contradictions that occur when one party tries to move and make a situation work for them, despite what the merits of the situation might be. And I think that that is a very real point. I do think that this particular bill has tremendous problems. I'm going to vote no on it. I think that if we are to think about the central issue here, it is the question of where expertise should lie. And at the end of the day, I think part of the reason that this administration has been focusing so intently on destroying agency authority, getting rid of expertise within the agencies, and replacing that, either completely eliminating a department illegally that was established by Congress, or eliminating expertise that has been critical to making these decisions over these years, is because they know that those agencies are actually accountable to Congress. So when we write legislation and we articulate what we intend to be done, it is very difficult, I think, particularly in technical areas that cross a number of different sectors, for us to give full and complete determination of exactly what that looks like. And so we have seen Chevron deference in the 40 years that it's been the law of the land require courts to give expert agencies the chance first to implement ambiguous laws, and that has led to an enactment of many important policies. And, I'll just name a few: how to limit greenhouse gas emissions under the Clean Air Act, which drugs and medical devices should be covered by Medicare and Medicaid, or how labor unions across the country hold free and fair elections without the interference of greedy employers. None of those things would have been possible without Chevron. And you could probably say that of the decade before as well. So I don't dispute that point at all. But I do think the central question is, who decides these important policies? And when Congress makes a determination, when we enact a law, that we do delegate some responsibility to the agencies. And I think that judges have another very particular set of expertise, a very particular range of expertise that they offer, which is critically important. And they, before the Supreme Court ruled recently, they had sort of the end analysis of whether something was appropriate or not, but they didn't have to have the detailed technical expertise that we have relied on agencies to have. And so I think it is very important that experts decide on subject matter as much as possible and that they are accountable to Congress. Because if you take that away, then you have a judiciary who is not accountable to Congress, and they might interpret exactly what they think the law should be based on a whole range of things that we may or may not agree with. And I think we've got to be very careful about, A, codifying the Supreme Court's, it is the law of the land, I'm not arguing with that, but codifying it in hopes that perhaps this returns us to a period of the 40 years prior to Chevron deference, because I think so many things have changed. And I also think at the end of the day, we should be looking at this on the merits of the situation, not by whether the current administration is taking away the ability of agencies to do the things that they are supposed to do, because frankly, an administration that wants to destroy the agencies and the separation of powers between Congress and the executive branch and seeks to essentially eliminate the authorities of Congress under Article 1 is also the same administration that might do that with the judiciary. For example, might ignore the unanimous Supreme Court decision to facilitate the return of Kilmar Abrego Garcia. I mean, there's all kinds of things that can be done to eliminate the separation of powers. And I think we should be looking at where should expertise lie. In my mind, anyway, that is the central question of this point. And that is why I wrote the Stop Corporate Capture bill, because my bill offers a comprehensive blueprint for the kind of modern, people-centered regulatory system that the public expects and deserves. And I think it would level the playing field for all Americans to have their voices heard on these critical regulatory decisions. It would promote scientific integrity, public accountability. It would codify Chevron deference, and it would restore our government's ability to deliver results. So that is still where I am. And I think if we're going to have this conversation, I just hope that we can do it as a group and not just change our
Gentlelady's
position.
time has expired.
I yield back.
Is there further discussion?
I move to strike the...
Mr. Onder.
Yeah, thank you, Mr. Chairman. Well, I really commend Mr. Fitzgerald for bringing forth this bill. I really love this bill. In fact, I like it so much that on the campaign trail last year, I talked repeatedly about codifying Loper-Bright and for once and for all making it clear in statute that the Chevron doctrine is no longer the law of the land. You know, the 4 decades since Chevron have witnessed an enormous growth in the power of the regulatory state and the size and cost of the regulatory state. Unaccountable bureaucrats, so-called experts, have subverted, in many cases, the will of the people and vastly expanded the power of the executive branch beyond what was anticipated by either our founders or by the drafters of the statute that those unaccountable bureaucrats allegedly were interpreting. Not only that, there's been an enormous power grab by these bureaucrats of the Article 1 powers of Congress, of the power of judicial review that is so clear in our Constitution, and finally, the power of individual citizens and businesses, litigants, to go to court to defend their individual and property rights against the aggressive and inappropriate use of power by executive branch bureaucrats. So why do we still need this bill? We need this bill, as Representative Fitzgerald said, to make sure that other doctrines, other deference doctrines, don't continue to be abused by bureaucrats. And number two, we do not know what the composition of the court will be. So it is time for Congress to make very clear that the Chevron doctrine no longer stands and that so-called experts cannot rule our lives and the lives of businesses throughout this country. I thank the representative for this bill.
Gentleman yields back.
I yield
Is there
back.
further discussion? Mr. Nadler.
Thank you, Mr. Chairman. I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, when I saw that we were marking up a bill called the Separation of Powers Restoration Act, I wondered if that meant that our Republican colleagues were finally ready to assert congressional authority and stand up to President Trump's unprecedented power grabs. On issue after issue, the Trump administration has thumbed its nose at Congress and claimed practically unlimited power for the executive branch. And what has been the response of my Republican colleagues? Crickets. So I was heartened to see that we might consider a bill to finally reassert appropriate checks and balances and to restore the separation of powers that our Constitution has enshrined. But sadly, this bill would do nothing to respond to the crisis at hand. Instead, it would double down on the Supreme Court decision in Loper-Bright, enabling courts to ignore agency expertise and make it easier to overturn life-saving regulations. I appreciate Ranking Member Raskin's efforts to improve the bill, in particular by adding language from my legislation to overturn the Supreme Court's recent decision in Corner Post, which eliminated the statute of limitations on challenging regulations under the Administrative Procedure Act. I am disappointed that the majority would not agree to his offers. Without that language, this bill would allow for wholesale rollbacks of standing agency rules going back decades. This could lead to chaos, endless litigation, uncertainty for businesses, and ultimately a government that cannot effectively govern. Therefore, unless that language is placed in the bill at some point in the legislative process, that hasn't been yet, I must oppose the bill. I yield back.
Could the gentleman yield? Oh, I'm sorry.
Oh, I'll yield.
Yeah, thank you. I wanted to respond to the last two comments and really the last three. The whole point that the gentlelady from Washington made so powerfully about expertise. The problem, I think, is that expertise is in the eye of the beholder. I was going to ask the gentleman who I think had to leave the room. He was saying, we should not be deferring to so-called experts. We should be enforcing the law as it is. So here's an interesting case that has come up in this new administration. And this is what I mean about how, there's a do-si-do going on. The roles switch completely. So the new Secretary of HHS, Secretary Kennedy, has said that the Department of Health and Human Services is not bound by the Administrative Procedures Act and is not going to follow it. Now, I suppose he would be the expert here. It's hard to identify his particular views with expertise, but in any event, he's saying as the Secretary of HHS, he's not going to be bound by the Administrative Procedure Act. Well, that's an outrageous violation of the rule of law. I think we want a court to be reviewing that. And as the various cabinet members decide they want to go off on their own direction and disown the whole body of regulations that have grown up in their particular agency or department, I think that we are going to want the courts enforcing that. Now, unfortunately, President Trump himself has also said he's not bound by the Administrative Procedures Act. And I hope that all of us would agree that can't be right, because the Administrative Procedures Act is the way that we actually conduct the promulgation of regulations through the notice and comment period and through, all of the steps that are built in there. So, my problem, my only hang-up with this bill is the Supreme Court's decision in the Corner Post case determined that the statute of limitations runs from the point of alleged harm to a litigant rather than from the point at which the regulation was adopted. And I think that doesn't give anybody, especially the business community, which has complained about it, but also workers, environmental groups, it doesn't give anybody any predictability or order in the system. So personally, I would like to add what's in this bill with language that, that gets us away from that corner post approach and makes clear that we can build a lot more definiteness into the system. I thank the gentleman for yielding.
I yield back.
Gentleman goes back. Is there further discussion?
I move to strike the last word.
Gentleman's recognized under the 5-minute rule.
Thank you. I noticed my colleague on the other side made the point that this bill is able to attack a problem of bureaucrats usurping Article 1 power. And I took note of it because I don't hear my Republican colleagues talking about Article 1 power very much anymore, as Donald Trump and this administration have completely usurped all of Congress's power, the power of the purse, the power to use executive orders to overrule legislation, to cancel effectively to agencies that Congress created. But somehow you found Article 1 power when it comes to, quote, unelected bureaucrats. Now, I was a clerk for a district court judge in San Francisco who had a lot of patent cases. And really, they're so complicated and so technical that he might as well have thrown a dart at a dartboard to see which way it would come out. It was just beyond his expertise, which he would have readily admitted. And so the notion that judges somehow have more expertise about the intricacies of implementing complex laws, whether administrative laws, especially whether they be environmental or financial or in some other ways, is absurd on its face. And it may be politically expedient for my Republican colleagues to want to put this power in the court's hands, but it will make our system much, much less effective. And I'm frankly sick and tired of hearing the term unelected bureaucrat as if the patriotic men and women of our federal government who are working anonymously for the United States to execute our laws, to protect our borders, to engage in diplomacy abroad are somehow, because they're not elected to office, any less competent or expert than somebody who, I guess, who wins an election is preposterous. But I would note that if your concern is Article 1 power, I might encourage you all to speak up against this Department of Justice charging with criminal charges one of your colleagues for doing her job, her constitutional mandated job. Now, I know many of you think you take an oath to Donald Trump, but in reality, the oath is to the Constitution. And you ought to be very, very careful about continuing to stay quiet as this president ravages and destroys our democracy and completely undermines and devastates your Article 1 power. So if you're going to find God and recognize that there's Article 1 power when it relates to administrative law, I hope you will also find Article 1 power to stand up to a rogue authoritarian administration rather than continuing to sit quietly as your own power is taken away and your own colleagues are being arrested for what is so obviously a politicized, trumped-up, bogus charge. And
Will the gentleman just yield for a friendly but
Yes.
But probing question, I hope. Okay. So this is on the point of expertise. You have a lot of courtroom experience. Say there's a case about whether someone was driving DUI. There's no doubt that the chemist who knows about body chemistry and alcohol is going to know more than members of the jury. But we still leave the ultimate determination to the jury to use their common sense, but they're allowed to take in all of the expert testimony. So why is it that we would say we want somebody who has expertise to be making a decision on an ambiguous or inscrutable part of a statute rather than a court whose job it is to interpret the meaning of the law?
Well, it's clear the courts have to have a role, and I don't think any of us are saying that the courts shouldn't have a role, and that's why I wish we would work in a more bipartisan way to rewrite administrative law after Chevron, because this is a very, very important issue that will have many, many follow-on effects. But for a judge or a jury or anyone who's not a scientific expert or a specific expert in a field to learn an entire field without the benefit of those who are experts fundamentally undermines the efficacy of our laws and the implementation of our laws. So why we would shun expertise is beyond me. And I yield back.
Gentleman yields back. Question is on a, Ranking Member, what time?
Yeah, move to strike the last word.
Gentleman's recognized.
Just to complete that point, Mr. Chairman, and I appreciate it. Look, this is in defense of the Loper-Bright decision, okay? Loper-Bright did not negate or nullify or demolish the role of administrative expertise in the agencies or departments. All it said, in fact, it reaffirmed that if there really is a clear delegation from Congress to an agency, the agency can do it. But where it's not clear, then as a matter of law, Loper-Bright says the courts have got to be determining that rather than the unelected bureaucrat, whether that unelected bureaucrat is Joe Califano or Robert F. Kennedy Jr. That is, whoever is there doesn't get to define what the law means, but they do get to execute the meaning of the statute. So that's why, to me, the Loper-Bright approach seems compelling, and we should work with it. But I just hope that my Republican colleagues, who I'm siding with here, understand the import of the position they're taking. First of all, the last bill that we just discussed is utterly ridiculous from the standpoint of Loper-Bright. It vests all power in an unelected bureaucrat. The idea was you have the regulatory notice and comment period, and then everybody, for some reason, goes to the general counsel of the Small Business Administration, and that person gets to decide, as if that person is more expert than all the other administrative experts and better at interpreting the law than the courts. So that bill is precisely what I think is being condemned by Loper-Bright. But I also want my colleagues just to understand what's going to be happening over the next 3.5 years is that people like Secretary Kennedy are going to be coming out with their rules and their regulations, and the courts are not going to be deferring to them, and they shouldn't be deferring to them if they operate in a realm of ambiguity within the statute. And so I just want everybody to be clear, you're committing yourselves with this vote to that position, that the courts should not be deferring to, Attorney General Bondi with respect to a DOJ regulation or Secretary Kennedy with respect to an HHS regulation. It's going to be up to the courts. And I know a lot of you have been talking about impeaching federal judges because you don't like what they've been doing, and you haven't really bothered to say what's wrong with the legal analysis that is exercising you, but you still want them impeached. And you're moving in a very different direction now, and it's the direction I believe in, which is that the courts are the place where we go to find out what the law means. Like Marbury versus Madison said in 1803, it's emphatically the province and the duty of the judicial department to say what the law is. So thank you, Mr. Chairman. I just wanted to add that point.
I thank the ranking member. The gentlelady from Wyoming is recognized.
Well, I think we need to understand what Loper Bright did and what Chevron did, and we can do it by using some real-time examples. What the point of Chevron was if there was an alleged ambiguity in a statutory, in a bill, then they would defer to the agency's interpretation of what that statute meant, rather than going through the process of determining what the law is, which had been basically within their purview up until 1984. And so we got such incredible absurdities. For example, let's use the Clean Water Act. The Clean Water Act gives to the EPA jurisdiction over navigable waters of the United States. That is a specific term that throughout history we've known what it meant.
Great point.
But then all of a sudden, the EPA started interpreting navigable water of the United States to include mud puddles and irrigation ditches and water in borrow pits along highways and riffles of water in the sand out in the desert and pretty much anything that you could think of that might not be in a plastic bottle like this. So the EPA, taking the phrase navigable water of the United States, which 90% of the people in this room would be able to define what a navigable water was, but apparently the experts, the EPA, the people who know this, the people who are the experts that courts should defer to, could not figure out that a man-made irrigation ditch is not a navigable water of the United States. So what Chevron did is it required the courts to defer to an absurd interpretation, and this is just one example of that. What Loper Bright did, that decision said it is up to the courts to determine what is meant by, quote, a navigable water of the United States. Now, that doesn't mean that the agencies don't weigh in. The agencies still file their briefs. They still make their arguments. They still have the U.S. attorney, the assistant U.S. attorneys appear before them and say a navigable water of the United States ought to be interpreted this way or it ought to be interpreted this way. But what it also does is it made it so that everyday people could also go into that court and make their presentation and their arguments as to what a navigable water of the United States meant. And go back to the history of the Clean Water Act and why Congress never intended to include irrigation ditches, irrigation canals, borrow pits, mud puddles. The point of the Clean Water Act was for the federal government or the EPA to take jurisdiction over things like the Mississippi River, the Missouri River, the Colorado River, the Green River. But it sure wasn't to take jurisdiction over an irrigation ditch. It sure wasn't that was to be left to the states. Regulation of those kinds of water bodies are left to the states. Yet because of Chevron, our courts allowed the EPA to take jurisdiction over things that Congress never, ever intended. The Loper Bright decision has correctly righted that wrong. And it doesn't mean that the agencies can't still make their arguments, can't still come in and bring in their expertise, can't still bring their expert witnesses to testify as to what these various terms should mean, but ultimately it is for the court to decide. And in light of the fact that we have had some bad decisions, such as the Chevron decision come out, it is time for Congress to act and say it isn't up to these so-called unelected bureaucrats, because that's exactly what they are, to be making the decisions about what the law says. That is for the courts to make that determination. That's all that this bill does, is it just further clarifies the authority and the power and the jurisdiction of all of these various actors in all of these various lawsuits. With that,
Will the
I yield.
gentlelady yield for an affirming comment?
Sure.
I agree with you. And in fact, I think one of the problems with Chevron and our regulatory scheme is that every 4 years, regulations can swing wildly, which creates very unsettled expectations and is, I think, very difficult for the business community to plan around. And what I would suggest, if we can continue to discuss this, is that we figure out some way to establish that rules that are promulgated and affirmed by the courts cannot then just be changed every 4 years. And if there's some sort of a rebuttable presumption that a rule that's been confirmed, that's been promulgated and confirmed by the courts would remain in a new administration, I think our entire regulatory scheme would be much better off, and many, many businesses and other entities would be grateful for that.
Gentlelady yields back. Who seeks recognition? The question is on adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. In opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is reported favorably to the House. The gentleman from New York requests a roll call. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey?
Yes.
Mr. Massey votes yes. Mr. Roy? Mr. Fitzgerald?
Aye.
Mr. Fitzgerald votes aye. Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes aye. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott?
Aye.
Mr. Knott votes aye. Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Goldman?
No.
Mr. Goldman votes no. Ms. Crockett?
No.
Ms. Crockett votes no. Mr. Klein votes aye. Mr. Moore votes aye. Mr. Issa, you're not recorded. Mr. Issa votes aye.
Clerk will report.
Mr. Chairman, there are 15 ayes and 12 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. What have we got next? Pursuant to notice, I call up H.R. 3486, the Stop Illegal Entry Act, for purposes of a markup, and move that the committee reported favorably to the House. The clerk will report the bill.
H.R. 3486.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from North Carolina, Mr. Knott, for an opening statement.
Thank you, Mr. Chairman. It is my privilege to open remarks on this important bill that targets a very real problem that is posed by criminal illegal aliens that come into the United States for one purpose, and that is to commit crime. While here, they commit crimes of every sort. After deportation, they often return to the United States to continue committing crimes that harm Americans in every corner of the country. Our tolerance for this as a country and the ongoing harm that is posed by this class of illegal immigrants has fully expired, and this bill reflects that reality. First, let me begin by commending Congresswoman Bice and Senator Cruz for their dedication to this important issue in their tireless work in crafting excellent legislation, striking at the heart of this crisis that has yielded countless victims. The original version of this bill was drafted several years ago after a 32-year-old woman was tragically shot and killed by an illegal alien who had multiple felony convictions and had been deported from the United States 5 times. Tragically, her case is not an outlier. This has become far too common. As a federal prosecutor, I investigated, tried, and convicted many individuals who had been deported 2, 3, even up to and beyond 10 times. Yet they continued to illegally return with the intent to commit crime here in the United States. When speaking to these individuals, it was quite interesting to me because they became quite candid. They simply told me deportation alone was no deterrent for them returning here to commit crimes. Further, given the sophisticated criminal infrastructures that exist, in large part due to unchecked migration and decades of open borders, returning to the United States for these committed criminals is something that is far too easy and far too profitable. For these committed criminals, it is a simple cost-benefit analysis. There is little risk in re-entering the United States and a very high likelihood of profiting from criminal activity. The current law and the status quo lets illegal immigrant criminals off far too easy. Without a change in the law, they will continue to enrich themselves through crime in our communities, bringing with them murder, rape, property crimes, drug trafficking, organized retail theft, human trafficking, and of course the threat of terrorism. The legislation that I, along with Congresswoman Bice and Senator Cruz, put forth draws a hard line. We will no longer tolerate illegal immigrants who disregard our sovereignty and our laws and are involved in never-ending crime that harms the American people. With the tools in this bill, law enforcement will now have a set of tools that will make it more efficient and easier to dismantle organized crime rings across the country. And most importantly, it will employ a deterrent to those hoping to illegally enter the United States to continue to commit crime. Utilizing my experience prosecuting these criminals, I worked with Ms. Bice and Mr. Cruz to propose the following simple measures. If you are here illegally and you commit a felony and you are convicted of a felony, that alone makes the illegal alien eligible for a separate federal offense that carries a minimum of 5 years in federal prison. Secondly, rather than capping the sentence for illegally re-entering, so after deportation, if you illegally re-enter the country, the current cap is at 2 years. The new maximum will become 10 years for all illegal re-entries, regardless of your criminal history. If an illegal alien is convicted of any felony, deported, and then illegally re-enters the country a second time, they immediately qualify for a federal charge that carries a minimum of 10 years in federal prison and a maximum of life. The premise of this legislation begins with the reality that anyone who is in the United States illegally, who is guilty of criminal conduct, what triggers these penalties in this law is either illegal re-entry or the conviction of felonious conduct while you are here in the United States. Yes, we need the wall to be finished. Yes, we need deportations. The president has shown that these steps are essential and effective. However, these measures alone are insufficient to deter and properly punish committed criminals from around the world from coming back to the United States. The only aspect of American law that strikes fear in criminal aliens is mandatory prison time. I know this from firsthand experience. Only in this way can we send a message that we will no longer tolerate the victimization of Americans through illegal conduct by criminal illegal aliens. With this bill, we change the cost-benefit analysis for the criminals, who will now have to conclude that it is no longer worth it to come into the United States or to return to the United States to pursue illegal activity. It's time for the illegal immigrant criminals to know that our tolerance for their presence and their criminal behavior here is over. With that, thank you, Mr. Chairman. I yield back.
Gentleman yields back. Chair now recognizes ranking member for an opening statement.
Thank you very much, Mr. Chairman. I want to salute Mr. Knott on his legislation and on his presentation of it. But this seems to me like a solution in search of a problem, and it's also a solution which seems to collide with the overall thrust of this administration's current policies regarding immigrants to the country who commit crimes. Now, under 8 U.S.C. 1325, entering the United States today without inspection or making false statements when entering or attempting to enter the country is already a criminal misdemeanor punishable by a fine and or up to 6 months in prison with enhancements of up to 2 years. Under 8 U.S.C. 1326, unlawfully re-entering the country or being found inside the United States following a removal order or denial of admission is already a felony punishable by up to 2 years in prison. With enhancements, the sentence can go as high as 20 years in prison for those who were ordered removed following a conviction for certain offenses. These laws were passed in 1929, nearly a century ago. Now, presidents of both parties have used these laws to prosecute people who enter the country unlawfully, and it's never been shown to deter illegal migration. In fact, in the last month of the Biden administration, as in prior years, 8 U.S.C. 1326 was the most commonly prosecuted criminal statute in the entire federal system. Yet there's been no correlation between increased prosecutions under this statute and a decrease in border crossings. If prosecution alone were a deterrent, we would have solved this problem long ago. We've not. But now the majority wants to impose more mandatory minimum sentences on existing crimes of unlawful entry and reentry, and even allowing for a life sentence in federal prison for merely entering the country unlawfully with no other criminal conduct required. We've seen over and over again that mandatory minimum sentences are not effective at deterring or reducing crime. And just a few years ago, there was a very broad consensus from left to right among both parties that mandatory minimums did not improve public safety. They stripped judges of their ability to exercise discretion to impose sentences that actually fit the circumstances of the case, frustrating judges' ability to consider mitigating factors and imposing this one-size-fits-all approach that so enrages judges. That's why the Judicial Conference and so many groups devoted to improving the criminal justice system oppose mandatory minimums. Senator Rand Paul, testifying before the Senate Judiciary Committee a few years ago about mandatory minimums, said, quote, "I am here to ask that we begin today the end of mandatory minimum sentencing," end quote. Study after study has shown mandatory minimums do not work to deter criminal behavior. We know that it's the certainty of being caught and being quickly punished, not the severity of the sentence, that is what really deters criminal behavior. Increasing and mandating lengthy sentences will not deter illegal reentry based on everything we know. In fact, just last week, we held a bipartisan hearing on what the majority called the overcriminalization and the growth of federal offenses, where colleagues seem to agree across the aisle that our federal criminal code is out of control. We even discussed Representative Roy and Representative McBath's bill, the Count the Crimes to Cut Act, because no one even knows how many crimes there are actually in the federal code today. Yet here we are just a week later marking up a bill to unilaterally impose new mandatory minimum sentences. At that hearing, we also discussed how the Bureau of Prisons faces significant staffing shortages, particularly of correctional officers, healthcare professionals, and mental health specialists. According to a DOJ Office of Inspector General report released in March of 2023, more than 20% of the Bureau of Prisons authorized correctional officer positions remained unfulfilled. forcing prisons to use cooks, teachers, nurses, and other kinds of workers to guard inmates. This dynamic will only get worse if BOP employees are asked to bear the burden of having their incentive pay cut and lose their FERS Social Security retirement supplement as a result of this week's big, beautiful bill that we stayed up all night talking about. In the last 7 years, BOP staffing levels have dropped more than 20%, bottoming out at a current 40% shortage now of correctional officers, according to AFGE. According to a GAO study on inmate deaths, staffing shortages create dangerous conditions. It costs the Bureau of Prisons $150 a day to house an inmate. And given all that, do we really want to make the situation worse by forcing the Bureau of Prisons to take custody of even more people now for 5 or 10 years when the current sentences have worked for nearly a century? Just think, a 10-year mandatory minimum sentence for an individual is a mandatory cost of over $500,000 for the U.S. taxpayer. That might be great for the private prisons who are making money off of this situation. It is not great for the taxpayers. So how is this going to be paid for? Who's going to pay for it? Finally, it's interesting that we are bringing forth this bill, which puts mandatory minimums in place on deportable undocumented immigrants at a time when President Trump has already gotten rid of one ICE director for not deporting people fast enough. In fact, under President Trump, removals are down over 10% compared to when President Biden was in office. If this bill were passed into law, it would require that deportable, undocumented immigrants who commit certain crimes be held in the overburdened BOP facilities in the U.S. at a cost to taxpayers of more than $150 a day for a minimum of 5 or 10 years, only then to be removed from the country. So have we actually checked with the White House to see if they would sign this legislation into law? Why would we choose to detain people for an extra decade or an extra 7 or 8 years in federal prison when the immigration laws already require that they be deported? According to the Washington Post, the Trump administration is pressuring governors to commute the sentences of immigrants right now, people who are convicted of serious crimes, so that ICE can take custody of them and remove them more quickly from the country. This bill does the opposite. It would require that deportable immigrants be held in federal prisons for 5, 10, even 15 years before they can be removed. So it would seem to directly contradict what the president desires and the thrust of his policy. How will he move with dispatch to deport a criminal who's serving a life sentence? So bottom line is, I think the legislation, while well-intentioned, seems punitive, expensive, ultimately ineffective, and somewhat baffling in the context of where the administration is going. I hope we can rethink it and work on some other solutions, and I yield back, Mr. Chairman.
Without objection, all of the opening statements will be included in the record. The chair now recognizes the gentleman from North Carolina to offer an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of amendment. The chair now recognizes the gentleman from North Carolina to explain the amendment.
Yes, Your Honor, this amendment makes a minor change to the short title. It does not change the substance of the bill. The NS makes a small change to the short title by adding, quote, of 2025, close quote, after the, quote, Stop Illegal Entry Act, close quote. I urge my colleagues to support this amendment in the nature of a substitute, and I yield back.
Gentleman yields back. Who seeks recognition? The gentleman from California, then the gentlelady from Washington.
Chairman, this is a good start. And as I heard the ranking member, the first thing I noticed was he immediately went to the 10 years. And what I found interesting about that is the bill as written does go to 10 years, but that's only after you serve 5 years and you come back yet again. Additionally, I heard the ranking member say something that I hope he'll reconsider, which is that these things don't work. Well, I agree with him. 2 years apparently is just enough time to train on being a criminal a little better, get a couple more tattoos, and be ready to come back again. It's the reason that moving these mandatory minimums over time from 2 to 5 and 5 to 10 and 10 till El Salvador, if I had my way, in fact, may be necessary in order to make this happen. And I share with the ranking member the high cost of incarceration, but the higher cost of people being murdered by criminal aliens, people seeing the effects of repeat reentry by people deported for cause also has a cost. So I would hope that all of us would hear what the gentleman from Maryland had to say and agree with him. 2 years doesn't work. That's why we're here today, upping the minimums. And I would only add one thing in closing. I know there will likely be amendments from the majority or minority. I might suggest an amendment if you'd like it. And the amendment would be if you'd like to have, at some point, the option, at least in the first time, for somebody to be deported with the recognition that they would immediately be reincarcerated if found back in the United States, that might be a worthwhile consideration, that when somebody has a 5-year minimum, but they're deported in lieu of those 5 years, maybe, just maybe, they won't come back again. I know the gentleman wants to accomplish the one thing, which is to have people who have had their due process, been deported, not return again. And I would be happily work with any member on that. But I cannot for the life of me understand how if 2 years doesn't work, that somehow what we need to do is stay with where we are, which is 2 years.
Will the gentleman yield?
Of course.
Mr. Chairman, just as a point of clarity, I will add on to that by Mr. Issa. Nothing in this bill mandates that a mandatory minimum is charged. There is still the ability to deport. There is still the ability to charge a 0 to 10. The aim of this bill is for someone who has committed 1, 2, 5, 10 felony convictions, and they still come back into the country illegally. And I will submit also, again, echoing what Mr. Issa said, the real cost of illegal immigration and open borders is not measured by incarceration time, it's human cost. In 1990, the total death of overdoses was 4,500 people for the country. We're seeing that now, 2023 is 130,000. The last 20 years, it's over 1 million Americans have died from illegal overdoses. And again, this is a very specific group of people that are international criminals that are committed to coming to the United States to commit crime. That's what this bill focuses on. I yield back.
And reclaiming my time, I would only once again reach out to our colleagues on the other side of the aisle and look at the care that this bill has had and the effect that is happening on our streets. Those million people who aren't with us today, many of them because of this category of criminal, and ask you to please reconsider the voting against this bill that seems to be the intent of the ranking member. And with that, Mr. Chairman, I yield back.
Gentleman yields back. Gentlelady from Washington is recognized.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report.
I'd reserve a point of order.
Point of order reserved by the gentleman from California.
Amendment to the amendment.
Without objection, the amendment be considered as read. The gentlelady is recognized to explain the amendment.
Mr. Chairman, my amendment addresses a current urgent situation of the Trump administration ignoring judges' orders, ignoring the provision of due process, and wrongfully deporting people to other countries despite judges' orders. My amendment simply states that this bill will not go into effect until the Trump administration is able to return all the people who it admits it has deported in error. It is a stain on our country that this list of people wrongfully deported continues to grow. And I will just say that this amendment, I'm going to give you a number of examples, but it is especially important now as it appears that once again the Trump administration has openly defied a court order, has just unlawfully removed immigrants to South Sudan, and the administration will continue breaking the law and wrongfully deporting people until they're finally held accountable. So I hope we can do that today in a bipartisan way. I ask unanimous consent to enter into the record an article from CNN dated May 20th. Federal judge says Trump administration must maintain custody of migrants allegedly sent to South Sudan. This just
Without objection, so ordered.
So we all know about Kilmar Abrego Garcia. This is a father a husband to an American citizen who had what is called withholding of removal. This is a legal immigration status that specifically blocked him from being removed to El Salvador. And he won that status during the first Trump administration in 2019 by proving that he posed absolutely no threat to public safety and that he had a well-founded fear of persecution from gangs back in El Salvador. The first Trump administration never appealed that decision. Now, the Trump administration has violated the court decision, kidnapped him in front of his 5-year-old son, and shipped him off to El Salvador, the one place in the world that they were legally barred from sending him. They sent him to be locked up in a foreign gulag with the very gang members that he had just escaped, and they are using our taxpayer dollars, all of our money, to pay for him to be imprisoned over there. Now, the administration didn't deny that they deported him in error. They admitted that they deported him in error, and in a normal world, they would have tried to bring him back. And if they really thought he was a danger to the community, they should have gone through the legal process of presenting that information to a court to try to strip him of his legal protections. But that's not at all what they did. They doubled down. They insisted without any new evidence that he was an MS-13 gang member. They went as far as to hold up a photoshopped picture of his tattoos. This is desperation. When you don't have real evidence, you Photoshop things. Meanwhile, every single court that has looked at this case, including the Supreme Court, found that the administration was in the wrong, and the Supreme Court ruled unanimously, 9-0, that the administration needed to facilitate the return of Mr. Abrego Garcia. There are at least 2 other cases similarly. Daniel Lozano Camargo, who is a Venezuelan man, was deported to El Salvador in March, despite a court-approved settlement requiring the administration to adjudicate his asylum claim first. And again, the Trump-appointed judge ordered that the administration facilitate Mr. Lozano Camargo's return, and the Trump administration has not done so. A Guatemalan man sued the Trump administration in March for deporting him to Mexico despite a fear of persecution. And immigration officials initially said that the man told him themselves that he was not afraid to be sent there. But in a court filing on Friday, the administration acknowledged that their claim was based on erroneous information. So these are just the beginnings of these wrongful deportations. And I think every US citizen out there wants the Trump administration, every person in this country wants the Trump administration to abide by the courts and by judges' decisions, and they are willfully defying that and deporting people, including people who have legal status. This is not about going after the worst of the worst that the bills keep bringing up over and over again. This has nothing to do with the campaign promises that Trump made. This is about deporting wrongfully people, sending them to other countries, and refusing to obey even the Supreme Court. And I will tell you, I don't think Americans want that. I don't think they believe that that is what should happen. And I would like for the other side to vote on this amendment that says nothing in this bill goes into effect until you return those wrongfully deported people and you obey the Supreme Court and judges across this country, including those appointed by Donald Trump, in their rulings to return these people to the United States. I yield back.
Gentlelady yields back. The gentleman from...
Mr. Chairman, I move to...
Hang on a second.
Chairman, notwithstanding that this is overly broad and outside the scope of this bill, I'll withdraw my reserve.
Point of order is withdrawn. The gentleman from North Carolina is recognized.
Move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Well, just a few points of correction and clarification in regards to the statement stating that Mr. Kilmar Garcia was not a threat to public safety. I have to strongly disagree. Having prosecuted organized criminals for almost a decade.
Yield?
No, ma'am. After over a decade, the evidence is overwhelming, both officially on the
Why
record.
don't you present it in
I'm
court?
speaking, ma'am.
Time belongs to the gentleman from North Carolina.
The evidence is overwhelming that he was engaged in nefarious conduct, that he was part of terrorist organizations, and he was working actively to further his criminal objectives here on American soil. His domestic partner or wife, whichever one she is, she took out paperwork with a court stating that he was abusive to her. He was stopped in Tennessee with, I believe, 8 women in a van, trafficking them around the country. This is not the person that we need to be taking up our arms for. But in regards to the gentlelady's concerns about due process, this bill protects due process. If someone is here illegally and they do not get convicted of a felony, it does not trigger this law. For someone to be convicted of a felony, they have to be charged with probable cause by a grand jury. They have to be arrested or otherwise apprehended. They have to be given counsel at your expense. They enter into a plea negotiation or a jury trial where they either admit to criminal conduct under oath or they're convicted by a jury of their peers. Once that happens, this law is triggered. Due process is protected. If you are convicted of felonious conduct in the United States and you are here illegally, these penalties come into play. If you're here illegally and you do not commit any crime, this law does not touch you. It targets the worst of the worst. It targets those who come back here illegally time and again to prey upon my children, my neighborhoods, people in your district, ma'am, and the time for allowing that is over. This bill gives law enforcement the tools to attack the committed criminals from around the world who come here illegally. Mr. Chairman, I yield back.
Would the gentleman yield just for one quick question on that point?
Gentleman yields.
Wait, am I reading the statute wrongly to say that a person could be put in a prison for a longer period for no other crime other than reentry?
Well, there's two answers to that. First, it elevates the sentence from 0 to 2 years to 0 to 10. In 2 years, it can take 24 months to resolve a case in 2 years, 24 months. And if it takes 21 months to resolve a case, there's only 3 months of active time that you can bestow. So it elevates it to 10 years. But secondly, the mandatory time only is initiated if someone has been convicted of a felony here in the United States and then returns illegally. Does that make sense?
But but the initial entry itself is a felony, right? So I guess what I'm getting at is you don't need to have murdered somebody or assaulted somebody or robbed somebody. Your crime could just have been an extra reentry.
Illegal reentry with a felony conviction.
Yeah.
And again, I will state for the record, there is nothing that compels prosecutors to have to charge that. But if the felony is sufficiently serious, if they're sufficiently dangerous, et cetera, and they come back illegally, that hammer exists to be used.
Would you entertain one other question, Mr. Ryan?
Absolutely.
But I guess this was back more on Ms. Jayapal's point. This relating to the Abreu-Garcia case and her amendment, which obviously is a kind of a preface to your bill. She's saying, before we go down this road, let's see that we're complying with the court orders that exist now for the return of people who've been unlawfully deported in an administrative error, right? And then the answer to that was, this is a terrible guy, he's MS-13, he's a terrorist and so on. He's not been charged with any of that, and he hasn't been convicted of any of that. And so are you saying the Supreme Court got it wrong in saying that there should be, facilitation of his return to the country, and that these people should be returned to the country, and they can be charged with anything at that point? I mean, maybe they're the worst person in the world, maybe they're not, but that's what due process is all about.
I'm not talking about taking a position on the Supreme Court's opinion. I'm not taking a position on the executive branch's position. I trust that they have stated repeatedly they are working to effectuate the court's order. But in regards to this particular amendment, I think it's irrelevant to the bill. This bill targets those who are around the world that want to come here to profit through crime. It's obviously a need. We look at the effects all around the country, and elevating the penalties, elevating the focus on illegal re-entry, that's the focus. And again, there is no compulsion to charge mandatory minimums. Those are only reserved. It's just one added layer of ability that law enforcement will have to target this class. Thank you.
Gentleman yields back. Gentleman from California is next.
Thank you, Mr. Chairman. My friend from North Carolina, I think we're all in agreement here. Nobody wants violent criminals in our communities. With or without documents, citizens or not, we don't want those individuals in our communities. Your focus on reentry, that's an interesting one. You want to reduce undocumented entries into this country. I think you have it a little bit off target, because if you really want to go after undocumented workers, you need to go after the employers, the people that provide them with jobs. Go after the small businesses, the farmers, the dairies, the home builders, the manufacturers. In California, manufacturing is big. 70% of those workers are undocumented. The employer is the key. People come back to this country to work, and that's who you want to keep. So if you want to keep them out, just tell the employers don't hire people. Now,
Will the gentleman yield?
not yet. I will, but let me finish here. This is a Wall Street Journal article from 2 days ago. I'm going to read it to you. It says, President Trump's mass deportation push has caused widespread fear among immigrants. What it has not done is stop them from showing up to work. As of April, there were 32 million foreign workers. 32 million foreign workers in the U.S., up 4.4% from January of last year. So they're still being hired. So here's the situation, sir. Make it illegal, penalize employers, triple down on the penalties, time in jail. You're going to give employers a choice. You follow the law, fire undocumented workers, and you go out of business. Or you ignore the law, keep your undocumented workers, and stay in business. That's a choice you're going to have the employers decide on. I'm going to mention a couple of more articles. This one is from the National Milk Producers Federation. 51% of the workers in the dairy business are immigrants. Not enough H-2A visas. Well, those are temporary workers. They need year-round workers. Wisconsin Examiner. Nowhere would mass deportations have a bigger impact than on Wisconsin's dairy farms, where about 70% of the workforce is made up of immigrants from Mexico and Central America. Got one more article for you. Nebraska Public Media. Dairy farms are vulnerable to Trump's mass deportations. The industry hopes to get a pass. So we're trying to slow down undocumented workers. The problem is not penalizing workers or employers. We got to have immigration reform. Give an opportunity for an employer to hire a worker legally. These workers from the U.S. are children. We are not going to work in farms, dairies, or manufacturing plants. So, this is essentially a charade. You're telling people that are starving, don't come to the U.S. You're telling employers that need the workers, don't hire them. The Wall Street Journal tells you clearly, since January, employment of undocumented in this country is going up. So let's figure out immigration reform. And sir, I would welcome the opportunity to work with you to come up with a solution to this problem. It's not about undocumented. It's not about employers. It's about the American economy and keeping it growing and keeping us as the greatest economy in the world. I got 38 seconds. I'll yield to you.
Thank you for the clarification, sir. And just a point of further discussion, I will say I'm not going after the dairy worker. I'm not going after the construction worker. This bill targets the individual who comes back into the country.
If I may, a lot of those come back as reentries.
With a felony. If the dairy worker does not get convicted of a felony, he is not under this law.
If he comes in again to the U.S.?
Illegally. Illegally. If you get deported.
Yes, these are illegal workers.
If you get deported, don't come back illegally. Come back legally.
They will come back because a job is there for them. And again, more than happy.
Again, this bill targets convicted felons who want to come back into the country a second, third,
Mr. Chairman, I'd like to submit these articles for the record.
Without objection, they'll be entered into the record. I'll claim time and I'll yield to the gentleman from North Carolina, but just let me say, I believe the focus of the gentleman's legislation, or Ms. Spice's legislation that Mr. Knott has worked so hard on, is really what he said in his opening statement. It's the guy who's part of the cartel, part of the terrorist organization, who keeps coming back because he's making money from the cartel, giving drugs that have killed thousands of Americans. And if he does get caught, goes through the process, felony conviction, they send him back, you come back again, oh, the judge is going to be able to put you away for a lot longer time. Because we want to stop that guy who's bringing the fentanyl in. That's the focus, not on people who have a visa who are here working. It's on that individual. And I would yield to the gentleman from North Carolina.
That's exactly right, Mr. Chairman. And in regards to how this bill would work, again, from what I saw in my firsthand experience, there are people who will come back repeatedly to inflict harm on this country through crime. And this bill will make it more efficient to identify, prosecute, and remove those individuals from circulation, from our society. Again, if you are here illegally and you do not get convicted of a crime and you do not re-enter the country illegally, this bill does not touch you. Mr. Chairman, I yield back.
Gentlelady from Texas.
Thank you, Mr. Chairman. You know, I think I just want to kind of distill down what my colleague, Ms. Jayapal, is talking about, and I am definitely going to yield some time to her. I think our concern is that because somebody says something, that doesn't make it evidence. And right now, what we have is people saying, well, we have evidence. As attorneys, we know that that evidence has to be tested in court, and that is what due process really looks like. It's not just saying that somebody is MS-13. It is a matter of a judge determining whether or not that evidence would be admissible and having the ability to look at the credibility of the witness offering that evidence, such as when we're talking about Kilmer. If we look at that, it says, I've got a couple of articles. There's an article that says government's case against Abrego Garcia is based on PG County cop who was on the SA's do not call list because he was not a credible witness. The only person that said that he was MS-13 is a cop that ended up being, I don't think he got fired, but he definitely, oh, okay, never mind. He did get fired. So we're going to say that we're going to base our entire case, so to speak. This is why we have courts. This is why we are talking about due process, because that's what it looks like. It looks like more than somebody. Listen, I can't tell you how many lies are made up by MAGA followers about me. I done been all kinds of things, and none of it is true just because they put it out there on social media. That is the problem that we're having right now in this country, is that it seems like nobody cares about the truth anymore. And what we're trying to do is say we have a fact finding, and let me be clear. I am not saying that the criminal justice system or any other justice system has ever always been perfect. I am not trying to say that. But we do have a system, and that system is supposed to be based upon the Constitution. And right now, like literally due process comes from the Constitution. This should be the highest protections that one can have in the land. And right now, it seems like y'all don't care about the Constitution unless it's the Second Amendment, and that's misinterpreted as well, okay? There's other amendments to the Constitution, and we don't get to just change it because our fearless leader says that he doesn't like certain parts of the Constitution. We have a process, again, to get amendments. Right? There are people that don't like the fact that there was an amendment so that women could vote. And guess what? We ended up with something like the SAVE Act because we don't want women to vote. Like, literally, but I'm getting off track, so I'm going to go back because I know that Ms. Jayapal wanted some time. So I will yield my time to the gentle lady from Washington.
Thank you so much, Representative Crockett. Look, I want to go back to the amendment, which says nothing in this bill can be enacted until we follow the courts and return these wrongfully deported people to the United States. And I would thank the sponsor of the bill for at least ensuring that there's a conviction in this bill. A lot of the bills around immigration that have been brought up to the floor of the House do not require a conviction. And so I appreciate that you put a conviction in.
Not too late to co-sponsor.
I believe that that is an important threshold that should be, and I hope that maybe you voted against all those bills. I'm going to go back and check. I don't think so, but maybe you voted against all those bills that didn't have a conviction, because we voted on a lot of them, and they don't have convictions. So I appreciate that you put in a conviction here. Here's the problem. I think you believe in due process. You said you have experience arguing in courts. I assume that you respect court decisions, but I have not heard a single person on your side speak out and say that the administration must return Kilmar Abrego Garcia to this country when the President of the United States said he had the power to do that. And when you say to me, oh, there's all this information on Mr. Garcia, Abrego Garcia, and he's this and he's that, I guess I'm surprised at that, because if you really believe in due process in the court system, and I believe you do, I'm going to give you that benefit of the doubt, then why not present that information in court? The Trump administration has refused to present information in court. They have, and the judges, when they've looked at the things that are there, they're saying, nope, not good enough, doesn't meet the standard. So why don't you all issue a statement from the Judiciary Committee Republicans, happy to co-sponsor it with you if you'd like, that says that you believe that the Trump administration should follow the ruling of the Supreme Court of the United States and any judge that rules, including those judges who were appointed by Donald Trump, to return these wrongfully deported individuals to the United States, because it is undermining everything that you've done in your career, everything that we stand for on this committee, to not speak out about it and to act like somehow this is okay. I think whatever you believe about Mr. Abrego Garcia, you should be able to say that he should have due process and that the Trump administration should follow the Supreme Court. So if you're, and I think that this is relevant to this bill, and so I hope that we can do that together. I doubt it, but I hope we can do it together.
And Mr. Chairman, I have two UCs. The first one is this article that says governments, what I said before, but more specifically, Mr. Menendez filled out the gang-filled interview sheet that deemed Abrego Garcia a member of MS-13 based on the fact that he was wearing a Chicago Bulls hat and hoodie.
Objection.
And the other one is, it says Trump's case against man deported in error just took another big hit. Trump world claims Kilmer Abrego Garcia was in MS-13, but new information concerning the local cop who attested to that charge at the time raises fresh questions about it.
Without objection.
Thank you.
Gentleman from California is recognized.
Thank you, Mr. Chair. I just wanted to briefly address a point brought up by the representative from Texas, Ms. Crockett, who accused me and my colleagues over here of ignoring the Constitution. And if that were true, that'd be a very serious matter. So I did want to just inquire as to what exactly the accusation is. So I'll happily yield to the gentlewoman from Texas if she'd like to respond. Do you believe that someone who has snuck into our country, entered the United States illegally, that the due process requirements for that individual are the same as they are for a U.S. citizen?
I thought the question was for me, but it seems like the lawyers on this side or just my entire team knows the answer.
Mr. Chairman?
Per the Constitution, yes, if you are on our soil, you are guaranteed due process. And the fact that there's even a question is why we are struggling right now. In addition to, an additional issue that I have is the executive order that was signed by the president that seemed to get rid of birthright citizenship, which also is laid out in the Constitution, which is why even the most conservative judges have ruled against, there is no one that has ruled that that was okay.
Okay, thank you.
You're welcome.
So
thank you.
That's simply untrue. The Supreme Court has made it very clear that due process is a context-dependent inquiry. And someone who is here illegally in this country facing deportation, the requirements of due process are specific to that context. And the problem is that during the last administration, we had 10 million people who came into this country without the least amount of vetting. And it's created an enormous backlog in our immigration courts. Now, what we actually did in a measure that we passed in this committee a couple weeks ago, which I believe every member of the Democrat minority opposed, is we sought to provide the resources for our immigration courts to operate in a fair and efficacious manner by increasing the number of immigration judges, of lawyers, of courtrooms, in order to remove this backlog of millions of cases that now exist. So I think it's highly problematic to hear arguments about due process from the side that is actually voting against providing the resources that are needed for due process. But I think it's even more problematic to make the argument that an illegal immigrant, perhaps with a criminal record facing deportation, should receive the full measure of due process that an American citizen does. That simply is not what the Constitution requires. I yield back.
Mr. Chairman.
Can I answer, since you still have time?
Yeah, I'd be happy to yield for a response.
Okay, thank you so much. So I just want to clarify, and I know that there's lawyers on that side. It's just like we have different standards in general. Like you have a higher standard when it comes to a criminal case versus a civil case, right? So its preponderance is going to be the burden on a civil case, and then it's going to be higher as it relates to a criminal case, right? It's beyond a reasonable doubt. That is going to be the burden of proof. When the Supreme Court was making distinctions, the distinctions weren't necessarily between is this person a citizen or is this person not. It wasn't a matter of certain people are not allowed to have due process, but it's kind of like there's different ways to evaluate things. The amount of protections that you are going to have in any criminal case. If you think about those that are charged with murder, whether they are a citizen or not, guess what? The burden of proof is still going to be the same. The burden of proof is still going to be beyond a reasonable doubt. There was never a distinction that said somehow, dependent upon your status, you somehow lose your access to due process. And frankly, that is honestly the only thing that the Supreme Court has been consistent on, is that there are due process rights that are going to be afforded to everyone that is found within our jurisdiction in the United States. I have not seen a case where they have said, no, it's okay for someone not to have due process. That is why the plane that was about to leave Texas, they said stop the plane literally at 1 a.m. because there had not been due process for those that were currently being held in the administration's custody. And thank you so much.
Thank you. I think I understand your position a little better now. I can't say I agree with everything you said, but I would just say perhaps be careful with throwing out accusations or ignoring the Constitution, without carefully considering those statements, because the demands of due process is not just something that is the same in every context. It's
Mr.
very
Chairman,
much
I have a
context
unanimous,
so I yield back.
Unanimous consent request.
Gentlelady is recognized for unanimous consent.
I'd like to submit for the record the Constitution of the United States Fifth Amendment explained, so that the gentleman can see exactly what is in the Constitution, where it says no person shall be deprived of due process.
I would just point out the Supreme Court, as the gentleman from California has said, has firmly, I'm quoting the Rehnquist from Justice Rehnquist, has firmly and repeatedly endorsed the proposition that Congress may make rules as to aliens that would be unacceptable if applied to citizens.
But
There
currently
is
the
process
Constitution
due, but
says...
it's not the same process due American citizens.
Mr.
Without
Chairman, it just says no
without
person.
objection, the
and
Fifth
so-
Amendment will be entered in front of the Judiciary
Thank you
Committee's record.
so much. I just wanted to make sure everybody knows what the Fifth Amendment says.
We will take
Maybe
it.
we could introduce the 14th Amendment too, Mr. Chairman.
Okay, that's fine too. Well, you can introduce the whole Constitution. God bless you. Now I got 3 of you who are in line, and I'll defer to the ranking member because he's one of the 3 in line. But you can decide. You
Cool,
can
but let me go first. It should be quickly, guys.
Okay.
A few questions for Mr. Knott. I do want to reemphasize what the gentlelady from Texas said, which is, of course, the civil standard of proof is different from the criminal standard of proof. The criminal standard of proof that governs is beyond a reasonable doubt for both citizens and non-citizens before someone's criminally convicted. In the civil context, depending on specifically which one, it could be by preponderance of the evidence, it could be clear and convincing evidence. There are different ways of formulating it, but the critical point for everybody to understand is that the Supreme Court has said on a 9-0 basis that there must be due process before people are removed from the country. Okay, I want to get back to Mr. Knott. because the distinguished chairman of our committee advanced some questions, and of course it's always dangerous to base your image of what legislation does based on one hypothetical. So he offered a hypothetical relating to opioids and cartels. There's nothing in the language of your bill that requires proof of somebody being involved in a cartel or dealing opioids, right?
Oh, no, absolutely not.
That's not an element. Okay. No. And then our distinguished colleague from California, Mr. Correa, he offered a kind of different hypothetical.
Yes.
And of course, the chairman's is perfectly plausible, but his is perfectly plausible too. He says, you've got people, there are tens of millions of them, who are coming to America drawn by employers who are willing to pay them. And there are tens of millions of them working in the fields, working in retail, working in construction, working doing landscaping, and so on. A person, now, and here's where I want you to just help us tease out the meaning of your legislation, okay? The person I'm hypothesizing here is not an opioid dealer or a cartel member. This person has come over in the spirit of the people that our colleague from California is talking about. So comes to take a job on the farms, but he's there illegally. Now gets deported, so that's strike number one. He could be held for 6 months under current law.
Existing law.
Existing law.
Yep.
If he does it again, it's 2 years, but you want to change that to 5 years.
No.
No?
Do you yield?
Please.
So the qualification for a 5-year minimum is conviction of a felony here in the United States, while here illegally. That's number one. If in your hypothesis, Mr. Raskin, when that individual is deported and returns with no conviction, instead of 0 to 2 years, he would be subjected to a penalty of 0 to 10 years.
Wait, I say that again for the second time?
Yes, for illegal reentry, the penalty is amended from the existing law right now. Illegal reentry is capped for most cases at 24 months. That would be changed to 120 months, from 0 to 120 months. So there's
for the first or the second?
Illegal reentry.
Okay.
You're talking about 1325.
Okay, you're referring to 1326 now.
Correct.
Right, okay. All right. I guess, so here's what I want to get at in the limited time I've got. On the second round, they could be held up to 10 years under 1326.
Illegal reentry.
Okay.
Yes.
Would you go to page 5, if you would, on the amendment in the nature of a substitute? If you go to the bottom of the page, okay, and then this is where maybe I'm getting confused. Mandatory minimum criminal penalty for reentry of certain removed aliens, right? So if you were convicted of being removed 2 times, if you're the person who's been drawn by the magnet of a salary, an income for your family, like the one Mr. Correa was hypothesizing, right? And you've done it twice, that person may be fined under 18 U.S. Code and shall be in prison not less than 10 years. And then the other part I don't understand, if you would clarify this, and may be in prison for any term of years or for life. So I don't know what that means. Is that a drafting error? Or?
Again, the crux of this issue with the enhanced penalties requires a conviction before the enhancements are applied. So if someone is convicted of a felony, deported, and then illegally re-enters, or if there's enhancements that are spelled out on page 5, that's when the enhanced penalties are triggered.
But can you just explain, what does it mean to say, shall be in prison not less than 10 years? That does sound like a mandatory minimum, which I thought you were disclaiming before.
No.
Then, and may be in prison for any term of years or for life. Then suddenly it can become a life imprisonment. Is that right?
There's the way it's written, there's flexibility there, up to life. That's the intent of the bill.
The time of the gentleman has.
But may I respond briefly? In regards to these charges, there's always an element of prosecutorial discretion. A great example in today's world is marijuana is still illegal federally. It's everywhere. Prosecutors are choosing not to charge that. This bill gives the tools to law enforcement to go after, in an efficient way, the committed criminals doing harm in the United States. That's the target. And they're illegal reentry or a conviction is what triggers the penalties of this bill.
Time of the gentleman has expired. The gentleman from Kentucky is recognized.
Thank the chairman. I want to speak to the bill generally. I think it addresses an important problem. I think it's a serious bill, and I think something needs to be done. But I cannot support the bill with mandatory minimums. I've been here a dozen years and haven't voted for a mandatory minimum. I think mandatory minimums run afoul of the intent of the structure of this government, which is to allow the judges and the juries to have discretion, because we cannot foresee here in this committee room every circumstance that might arise in the prosecution of these cases. And although I think it's otherwise a great bill, I will not be supporting it because it has mandatory minimums. Thank you, and I yield back.
Gentleman yields back. The gentleman from New York, and then the gentleman.
Chairman, I want to pick up where the ranking member left off. Whatever the intent of the sponsor may be, the bill clearly says that someone who enters the country illegally twice shall be imprisoned not less than 10 years and may be imprisoned for any term of years or for life. In other words, if you come across the border twice, you can get life imprisonment without committing any crime other than illegal entry. It seems a little draconian and to have the possibility of a life sentence, in addition to which you can be imprisoned for 10 years or up to life, and there's no standard for when it should be 10 years and when it should be life or 20 years or anything in between. There's no guidance for the judge. And unlike what I think the sponsor said, there is no requirement for a felony as a precondition to a life sentence. All that is required is 2 illegal entries.
Will the gentleman yield?
I will.
Line 9, it says, who was convicted under this section at least 2 times.
Yes.
Convicted.
Convicted of 2 illegal entries. Yes, no, I'm not quarreling with that. So in other words, if you illegally cross the border twice, you shall be sentenced to at least 10 years and up to life for no crime other than illegally crossing the border twice. And there is no guidance for the judge as to whether it should be 10 years or 20 years or 30 years or life. Most statutes, in fact, all statutes, give some guidance for the length of prison. This doesn't give any guidance for the length of prison. It simply says if you've entered the country twice, you can be sentenced to at least 10 years. All right, can't be sentenced to 5, at least 10 years, but up to life, and no guidance within that.
Gentleman yield?
I will.
Well, again, part of this goal's aim is to deter.
What?
It is to deter. It is to deter illegal reentry.
Reclaiming my time.
Yes.
I don't doubt it's to deter illegal entry, and it certainly does that. But it still gives no guidance to the judge as to whether to sentence someone to 10 years or 11 years or 12 years or life imprisonment. And that doesn't make any sense. If you wanted to say, if you wanted to say that the first illegal entry shall be sentenced to 5 years and the second to 10, or the first to 10 and the second to 20, it'd be a little harsh, I think, but it would make sense. But to say 10 to life with no guidance to the judge, with no standards, that makes no sense.
Gentleman yield?
I'll yield to Ms. Ross.
Thank you, and I'm going to want some of my own time after you do that. I wanted to make the point, and we've talked about this. You and I both represent North Carolina. We've talked about what you want to do, your main reason for even being here. This bill is everything to you. So I would hope you would want it drafted well. And I think the point that's being made here is, in addition to the mandatory minimum that Mr. Massey has raised, there isn't a disjunction between anything that's even longer than that. It actually says the mandatory minimum of 10 years and a prison sentence for any amount of time or life. And so it's not giving the judge the option of choosing between them. The judge has to do both. And so I just would ask the gentleman to consider that that might be a drafting error and not his intent. And, you know, it's going to take a long time for this bill to go everywhere. You know, the Rules Committee may never stop, and you may never get to rules. So let's take a little time. And if that is true, if it's truly your intent to give some judicial discretion to make sure that this bill doesn't mandate that judges do that.
Reclaiming my time, this bill says not less than 10 years and may be in prison for any years to life. It gives no discretion, it gives total discretion to the judge, no guidance, and that's the problem with the bill, in addition to its harshness. I'll yield.
Well, just briefly, again, a goal is deterrence, number one. Number two, mandatory minimums can be penetrated upon motion of the government. That's a well-established fact for substantial cooperation, 18 U.S.C., I think it's 3553E. Thirdly, mandatory minimums, whether it's drugs, continuing criminal enterprise, firearm statutes, et cetera, there's no discretion for the judge. That's what the attorneys...
Reclaiming my time,
that's what the attorneys...
It is a mandatory minimum in the bill.
Gentleman doesn't have time to reclaim.
And it is a mandatory minimum in the bill, and the maximum is life, and I would simply suggest that in looking at this bill, you give some standard to the judge for what to do. I yield back.
Gentleman yields back. I've kept Mr. Goldman waiting for 4 people, so I'm going there next, and then I'll come back to the gentlelady from North Carolina. If we don't, well, I'll go first, Mr.
Thank you very much, Mr. Chairman. My colleague on the other side of the aisle who shares a glorious past as a federal prosecutor in the DOJ with me says that the goal is deterrence of this bill, that deportation alone is no deterrent to returning here. I think the chairman said the goal of this is to prevent members of the cartel or parts of terrorist organizations from coming back to this country. And it almost feels like we are living in completely disjointed universes from what is happening down the street, where the president and his administration is desperately trying to deport people before their criminal case is completed. And in fact, my colleagues on the other side of the aisle passed a law that allowed for removal based on an arrest, based on allegations. So when my colleague from North Carolina and Mr. Issa from California talk about how this bill only applies to people who have due process, how can you square that with the fact that you supported the Lake and Riley Act, which does not include due process? And how can you square that with the fact that you haven't said anything in opposition to this administration's deportation of people without due process who have not had their day in court and have not gotten what you believe to be the benefit of deterrence from a criminal prosecution and a sentence? So you have a bill here that is ostensibly designed to increase the penalties against those people who illegally re-enter to deter them from doing that. And yet, you're also passing bills and supporting an administration that does the exact opposite. It's almost as if we're living in completely different universes. And in fact, the universe is so different that I want to flag a particular case for my colleagues on the other side of the aisle. Not too long ago, this Department of Justice dismissed a case against an alleged top leader of the MS-13 gang, who U.S. investigators believe has information that could implicate top Salvadoran government officials in possibly corrupt deals with the violent gang. And he was removed on one of the controversial flights that is the subject of litigation. So the United States Department of Justice worked hard as part of the task force Vulcan to extradite this individual to face charges in this country. Charges, very serious charges related to terrorism, racketeering, murder. And this was a top person in MS-13 who either would have served a long period in jail or perhaps would have cooperated and provided the United States government with very relevant and important details about MS-13, one of those cartels, one of those terrorist organizations that the chairman talks about. But rather than allow the deterrence to play out and the person to go to trial, this MS-13 terrorist to go to trial, be convicted, and serve a lengthy sentence, which is the whole thrust of this bill, this administration decided, no, we're just going to let him go back to El Salvador. And so that is the exact opposite. That's what you're worried about. That's what you're worried about. If we just deport people, they'll come back. And yet that's exactly what this administration is doing with top cartel officials and terrorists. Now, I have no idea whether this was a side deal between President Trump and President Bukele that is related to the payments that President Trump is making to President Bukele in order to imprison prisoners. There's no question. There's on the record reporting that President Bukele is in opposition to extraditing members of MS-13 because they may have information about him. So I don't know what the derivation of this was and why it happened, but what I do know is that this is a cartel member who was extradited, charged, would have gone to jail for a long time, and was dismissed by this Department of Justice just so they could deport him. So why don't you speak out against that rather than trying to elevate these illegal reentry prisons?
Gentleman's time has expired. The gentleman from California is recognized.
Thank you, Mr. Chairman. For 4 years, the Democrats deliberately flooded our country with more than 8 million foreign nationals who violated our immigration laws, illegally crossed the border, and the Democrats then trafficked them across the country, including the most violent criminals and criminal gangs and cartels on this planet. This administration was specifically elected by the American people to protect our citizens, secure the integrity of our borders, and restore the rule of law. Now, regarding the Democrats' obsession with returning Abrego Garcia to our country, the record's very clear, and I'll state it again. He was determined by 2 immigration judges to be affiliated with MS-13 after being arrested in the presence of known MS-13 members, wearing gang insignia and a gang tattoo, and in possession of $1,200 in cash and drugs. A confidential informant confirmed he was a mid-ranking member of MS-13. He was denied release on bond because while his immigration case was pending, because of the potential danger that he posed to the community. This is precisely the type of individual the Democrats want returned into our neighborhoods. This is exactly the kind of individual that this bill attempts to protect us from. The Democrats have made it clear, time and again, that if they're ever returned to power, this nightmare will resume and Americans will be held hostage to the most violent criminals in the world, protected by Democratic sanctuary laws and shielded by woke Democratic district attorneys. That is the choice that faces the American people. This administration was elected to protect us from this deliberate subversion of our laws, and it's doing everything that it can despite the opposition from the Democrats. The Democrats argue that even though he was ordered deported, he was ordered not to be deported to El Salvador, even though he's a citizen of El Salvador. Now, that order was not known to ICE when he was deported. It should have been, but it wasn't. Bureaucracies make mistakes. They shouldn't, but they do. Point taken. But now, what's the status of this case? Abrego Garcia is a citizen of El Salvador, in the custody of the government of El Salvador. The United States has no jurisdiction over him whatsoever. Now, the courts ordered the president to, quote, facilitate the return of Abrego Garcia, but it's conveniently failed to define exactly what that means. I think the reason for that is because they can't think of any act the president could take that a court can compel. If they could think of one, I think they would have specified it. So they leave an entirely ambiguous word because they can't define specifically what they mean. It's very clear that the court cannot compel the president to facilitate or conduct foreign policy, and yet that's the only order they could issue to facilitate Abrego's return. So I think the Democrats need to exercise a little self-reflection here and consider the position that they've taken and the danger that it poses to the American people.
Mr. Chairman?
I yield back. Yes, I'll yield to the...
No, I'm not asking for you. I'm asking for my own time. Oh.
Yielding, and I appreciate the context and clarification that he gave to the Abreu Garcia situation and to this bill. I just want to make sure that the committee understands what Mr. Knott is doing here. My understanding is the first time someone comes in the country illegally, that's a misdemeanor. They come a second time, it's a felony, and currently they could get 2 years. What this bill is going to say is, oh no, if they come in the second time, they could get up to 5 years with the judge. And then if they're kicked out again and they come back a third time, then it could go to 10 years or greater, again, up to the judge. And it's designed to make sure the Abreu Garcia guy doesn't keep coming back and doing bad things. Is that clear? And that's the experience of the gentleman who worked as assistant U.S. attorney. Is that? And I'll yield to the gentleman for a response.
Well, essentially, that's correct, Mr. Chairman. The provision of the bill says if you're here illegally and you receive a felony conviction, state or federal, you qualify for a new charge, 5 to life. If you're deported and come back, regardless of criminal history, 0 to 10. If you come back illegally for a second time with a felony conviction, that's what qualifies you 10 to life.
Mr. Chairman,
It's very straightforward. If you are, again, I will state this again, if you are here illegally and you do not commit a felony, this law does not apply. This is for the hardened criminal that is inflicting harm on this country, period.
Gentleman yield.
Time has expired.
Would the gentleman yield?
I will recognize you for, I think you're up next.
Okay. Let me,
I've got 2 UCs, Mr. Chair.
Hang on one second. We'll take the UC, then I think someone had to yield this one.
Okay, so the first UC is Mexican security chief confirms cartel family members enter U.S. in deal with Trump administration. That's from the
Objection.
Associated Press. And then there is another article. Is that admitted? Unanimous consent? Okay.
Yep.
The other one is what we know about Trump admin's reported deal allowing Mexican cartel family members to enter U.S.
Without objection.
Thank you.
The gentle,
They led in the cartel.
If we can get off the amendment, they all have time on the other
okay, but I think we got to get someone,
If we can get off the amendment, then everyone.
then you can claim time on the bill.
You'd be recognized first on the next one. Is that all right? Because they want to call the vote.
Question, I got it. The question occurs on the adoption of the amendment.
No, the amendment from the gentlelady.
Oh, that's right, the gentlelady from Washington. Question occurs on the amendment offered by the gentlelady from Washington. All those in favor say aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it, and the amendment is not adopted. Roll call, then we'll come to Mr. Nadler. Clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Grothman? Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgardner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Johnson, Mr. Swalwell, Mr. Liu, Ms. Jayapal. Ms. Jayapal votes aye. Mr. Correa, Ms. Scanlon, Mr. Neguse, Ms. McBath, Ms. Ross. Ms. Ross votes aye. Ms. Ballant. Ms. Ballant votes aye. Mr. Garcia. Mr. Garcia votes aye. Ms. Kamlager-Dove. Mr. Moskowitz. Mr. Goldman. Mr. Goldman votes aye. Ms. Crockett. Ms. Crockett votes aye. Ms. Kamlager-Dove, you're not recorded. Ms. Kamlager-Dove votes aye. Mr. Issa, you're not recorded. Mr. Issa votes no. Mr. Kiley, you're not recorded. Mr. Kiley votes no.
Clerk will report.
Mr. Chairman, there are 9 ayes and 16 noes.
Amendment is not agreed to. Who seeks recognition? Gentleman from New York. Gentleman is recognized.
Mr. Chairman, I simply want to say 2 things. Number one, what Mr. Knott just said a moment ago is not correct.
Turn on your...
You don't? Let me start again. What I want to say is that was 2 things. What Mr. Knott just said a moment ago is not correct. You need 2 convictions for a life sentence, not 3. Conviction number 1, illegal entry. That gets you 10 years. Conviction number 2, a second illegal entry, gives you up to life. And no standards for determining anything between 10 years and life. Secondly, what Mr. McClintock said about the Abreu Garcia case was totally wrong. It is true that that the 2 judges deferred to DHS's contention based on evidence from a disgraced fired cop. But an immigration judge during the Trump administration had granted him withholding of removal, which he would not have been able to get if he were a public safety threat. The Trump administration never disagreed with that, in effect. Now, they say all kinds of things. They say he's an MS-13 member, but they never proved it. They never showed any evidence of that. Just the mere assertion he's a Tren de Aragua member doesn't mean anything. Anybody can say anything. They have to prove it. They never offered any evidence at all. They went against a judge's order that he not be removed, and specifically not be removed to El Salvador, and they put him on a plane to El Salvador. Now, Mr. McClintock says, well, it's a foreign policy question as to whether he can be brought back. The Supreme Court said he should be brought back, that the court should, I forget the word it used, that the facilitate, that his return should be facilitated. But Mr. McClintock said, well, that's a matter of foreign policy. No, it's not. We are paying the El Salvadoran government over $6 million to detain these people. We could simply say to Dictator Bukele, return the person that the Supreme Court ordered returned, or we'll pay you less, or we'll pay you nothing. We have complete control of the situation, and refusing to do that is simply contempt of the Supreme Court. And some of these immigration cases may be bad, but completely ignoring orders of the Supreme Court is far, far worse than anything else we're talking about. I yield back.
Gentleman yields back. The gentlelady from Texas.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. Point of order reserved by the gentleman from California.
Amendment to the amendment and the
Without
nature.
objection, the amendment be considered as read. The gentlelady from Texas is recognized to explain the amendment.
Thank you so much, Mr. Chair. My amendment today would eliminate the mandatory minimums established under this bill. Now, I got all these remarks, but let me just talk to y'all very real. We have seen, and a number of people have admitted that they have practiced criminal law at some point in time in their lives. We have tried mandatory minimums, I don't know how many times, and every single time we have failed. And the definition of insanity is doing the same thing over and over, expecting a different result. And frankly, I don't know if y'all believe that there is going to be, you know, some kind of phone call, telegraph, or what will take place off into all of these foreign lands that says, you know what, we have increased the mandatory minimums, and so now you should be deterred. That is not going to happen. This is not successful. We have tried it over and over, and we have always failed. What we should do is focus on why is it that people would risk their lives to come to this country? Exactly what could be so bad going on where they are from that they would say, you know what, I will risk being incarcerated because I need to go and get that job doing the jobs that most Americans don't want to do, whether it is working on the farms or whether it's out there doing construction or whatever jobs it is that they have done to contribute to our economy. The question should be, how can we fix immigration? And I can tell you for sure the mandatory minimums have never fixed anything in this country, and I don't anticipate it's gonna fix this. The final point that I'll make before I have to go back to something else that we were talking about earlier is that we are not given the resources to those that are incarcerating folk already. So now we want to leave people incarcerated for longer amounts of time. We literally just had a hearing with the Bureau of Prisons, and they were talking about the fact that they are under-resourced. And so now that they're under-resourced, why not pile onto them and give them extra work? I mean, we somehow, or y'all somehow, found a way to make sure that ICE could get up to $42,000 worth of a bonus per person, yet the Bureau of Prisons, they get absolutely nothing except for what? More bodies that they need to somehow take care of? I don't think that that makes good sense. That is not fiscally responsible. I know y'all know that term. So I think that we should definitely vote for my amendment because we want to be fiscally responsible, and this is fiscally irresponsible. All right. Now, let me get to this other point. I was going to introduce this as a UC, and I will do that as well. Because I don't know why we still arguing about what the Constitution say. I'm still confused. So let me tell you what the Supreme Court had to say. In the decision AARP et al. Versus Donald J. Trump, President of the United States, this is the opinion that came down May 16th, 2025 regarding the Texas situation. It specifically says on page 3, so you don't have to read too far, in paragraph number 2, it says, the Fifth Amendment entitles aliens to due process of law in the context of removal proceedings. And they were quoting Trump v. JGG, which is also a 2025 case. They go on to say procedural due process rules are meant to protect against the mistaken or unjustified deprivation of life, liberty, or property. That's why we've been talking about Abrego. And then the next sentence goes on to say, we have long held that no person shall be removed from the United States without opportunity at some time to be heard. I'd like to enter the Supreme Court decision. I don't even like this Supreme Court. I want to point that out. I would like to enter this into the record for all those that don't understand what the Constitution says. And it's been reaffirmed by, this is Trump's Supreme Court. That's why I don't like it. I'm just be honest. It's been reaffirmed by his Supreme Court. Unanimous consent, Mr. Chair.
Without objection.
Thank you so much. I appreciate you. And I will yield back.
Gentlelady yields back. Who seeks recognition is, no, Mr. Van Drew's next.
Thank you, Mr. Chairman. So these constitutional discussions have been fascinating. They're interesting. I want to talk a little bit why this all happened. We keep going back to mandatory minimums. It just didn't happen by accident. There's a reason it happened. It's because we had prosecutors and attorneys general and judges that let people out over and over and over again, shortened their sentences, didn't fulfill the sentences as long as they should have, and they were allowed to roam the streets again. And people died, and people got raped, and people got disfigured, and people got hurt, mothers and fathers, brothers and sisters. So we are the ones at the federal level that write the laws, and at the state level, politicians reacted. They reacted because bad things were happening on the street, in plain English. So I don't love mandatory minimums either, and I've known throughout my years being involved in politics and government and public policy, people who've gotten hurt because of mandatory minimums. But when we have a system that allows, and we saw it firsthand, by the way, Chairman, you were with us when we went to Philadelphia. You were with us when we went to New York. You were with us when we saw the victims, and so were the ranking members, when they saw the victims of these crimes, these men and women, and literally saw families that lost their son that was in law enforcement. I forgot how many times he was shot. They threw him to the ground. They found the one spot he wasn't protected with a vest, and they shot him over and over again. The person who did that had been incarcerated, I don't even remember. I think it was more than a dozen times. So there's a reason they're there. When prosecutors do better, when we don't have extreme left-wing judges and extreme left-wing attorneys general and extreme left prosecutors, maybe then there won't be mandatory minimums. But until then, there is a reason, because people are getting hurt. And then the Bureau of Prisons. Look, I've always defended the Bureau of Prisons and the men and women that work there. I agree there's a shortage. I agree we had a hearing in our subcommittee about it. I believe we have to do better. I hope as we go through the next few years, it was horrible in the last 4, that we do better by the Bureau of Prisons, forgetting even about this reconciliation in future budgets, in future reconciliations. But the answer to do better in the Bureau of Prisons, because we have a shortage, is to encourage more people to choose that as a career, even regardless of how hard it is. The answer is not to allow illegal aliens who are criminals to live on and hurt people on the street and to, pass drugs off, to be drug dealers. That's not the answer to the problem we have with the Bureau of Prisons. The answer to the problem with the Bureau of Prisons is to fix the Bureau of Prisons. Bad people who've done bad things and they've broken the law once by not being here legally, but then they break it again. They've been deported. They've been sent over. They come back again. That shouldn't be allowed. They should be punished. When they've convicted a crime, they should be punished. And there is nothing in this bill that disallows you from detaining them, giving them due process, and deporting them, if that's the case. And especially in those cases when they're going to be deported to the country of origin and then imprisoned in that country.
Will the gentleman yield?
In a second. Who asked me that? You? Okay, yeah, it'll be a quick second. This doesn't stop deportation. It doesn't stop detention. Yes, we need to improve our immigration system. All that's true, and I'm going to yield now. But the reason we are where we are because of people like you that came to us and said we can't take it anymore. Our brothers, sisters, mothers, fathers, children are being killed, they're being raped, they're being beaten. We need these people to be put away. This didn't happen in a vacuum. Constitutional discussions are wonderful. I enjoy them. They're fascinating. But this is real life. It's real life in America, and it's real life in what's happening in our country. I yield.
Just briefly, sir, thank you. First, criminals, especially criminal illegals, are aware of penalties. That's why they come back here. They know that they're very lax, and that's why they aggregate in sanctuary cities, states, and towns. They know that that is a reprieve. That's also why we need this bill, to protect the people who live in sanctuary cities and the state and local governments will not do their duty. And we saw it quite clearly with Judge Dugan in Wisconsin. She literally abandoned her courtroom, her decorum, the prosecutor, and the victims in her courtroom to protect an illegal. This law gives law enforcement a tool to fight that hostile position that so many on the other side of the aisle have. I yield back.
I reclaim my time real quickly. It is perverse and bizarre and weird sometimes how the other side goes to such extraordinary methods and extraordinary amount of work to protect illegal criminals. I yield back.
Gentleman yields back. The ranking member recognized.
Well, let me start by answering my good friend from New Jersey, Mr. Van Drew. Why do we care about due process rights for guilty people? He raised a good question. Why did the Supreme Court go to such lengths to defend the rights of, illegals, as you call them? Because the Supreme Court said if we don't defend the due process rights of so-called illegals, we won't defend the due process rights of legals, of citizens. If we don't have due process for non-citizens, we're not going to have due process for citizens because you don't know even who's a citizen and who's a non-citizen.
Will you yield for a split second?
Sure.
Thank you. I would never do anything to say that we shouldn't follow due process. I never said that. I just said right in here.
Then we agree. When you say, why do people care about it? We care about it because we care about due process for everybody. That's why. So you don't need to pose that question again.
Those are words, and they're important words.
Well,
I'm
then
talking about people's
I'm
lives.
reclaiming my time. Then I'm going to ask the question, why do the right-wing Republicans not care about due process then? That's my answer to your question of why left-wing Democrats care about illegal aliens. Because the grammar of that question is meant to imply that somehow we're sympathetic to people who commit crimes, and we're not. And I also don't believe that you don't care about the Constitution, so I'm not going to do that. But I would appreciate it if you don't imply that we're somehow pro-criminal because we stand with a 9-0 decision of the Supreme Court upholding due process rights. Now look, I've got a simple question. I'm back to Mr. Knott, my friend, because I just want to figure out actually what this statute means, okay? And I'm with the distinguished gentlelady from Texas on mandatory minimums. I think there's wisdom in what our colleague from Kentucky has said about mandatory minimums because they don't work. But here, let's take a specific example, and maybe, Mr. Knott, you can help illuminate this for me, because I think I've figured out a hypothetical that will help us nail down what the real meaning of this language is. I thought when I first posed the question, you were going to say that was a drafting error, but you cheerfully conceded, no, you actually meant there's a 10-year minimum sentence, but a judge, based on his or her own discretion and whatever criteria he or she wants to use, can go all the way up to a life sentence. Fair enough. That's your position. I think that the distinguished gentleman from New York also misstated the meaning of this statutory language. He said you need 2 convictions before somebody could be sentenced to life. I read it, you could have 1 criminal conviction and you could be sentenced for life. Here's my hypothetical, and tell me if I'm wrong. Okay, so a person is drawn, in Mr. Correa's example, to a job working on a farm doing agriculture, okay? But he's an illegal. And then they find out about him, he's subject to deportation. He's deported from the country, okay? Now, if he comes back in again, having been deported once, say he goes back to the farm, he's prosecuted now under 1326. And that right now is punishable by up to 2 years. You're changing that to 10 years, but we don't have to take it to the extreme. Say the guy gets a 2-year or 3-year sentence, and he's deported again. For whatever, and I'm obviously now making the star of the story more sympathetic than obviously an MS-13 terrorist, okay? But the guy comes back again now after he's done, say, 2 years in prison. He comes back again. At that point, I'm reading the language on page 5 of your bill to say that because this alien was guilty of any crime punishable by more than a year, you made it 10 years, but he was convicted of it, now he must be in prison for 10 years, and he may be in prison for life, having that 1 conviction for before, which renders, kind of surplusage and, null and void the number 2, who was convicted under this section at least 2 times before such removal or departure. That looks to me like surplusage because you've already said if you're convicted of any crime punishable by more than a year, and he's gotten it. So, am I reading it right?
From what I picked up from you, correct. That is correct. But again, the intent of this law, as written, there is wide flexibility. It does not preempt existing authorities to detain, deport. It simply increases the penalties from 0 to 2. And if you have 1 felony conviction, that part you are correct.
Yeah.
1 felony conviction, you're deported. You return a second time illegally. that qualifies you for a 10-year minimum to life. Now, as you well know, the prosecutor has wide discretion in what they charge. The prosecutor has wide discretion in what plea offers are rendered, and they can choose to just simply move for a deportation. They can charge a 0 to 10, or if it's a heinous criminal who has 1, 2, 3, 5, 10 convictions, they can bring the 10-year minimum up to life. And to answer the question that was posed by your colleague from New York, the discretion for the judge, that's for the lawyers to handle at sentencing. Yes, relevant conduct can absolutely be brought about. It can be argued. It can be litigated. It should be. That's the way that the criminal law works in my experience. And when the standards are met, when facts are established and found by the court, a life sentence may be justified.
Thank you very much. You're back.
Gentleman yields back. Question occurs on the amendment offered by
Wait a minute. I've got 4 UCs.
UC's. Okay, we'll take them now. Go ahead.
Thank you. I have a unanimous consent request. I ask unanimous consent to enter into the record a statement opposing H.R. 3486 from the National Council for Incarcerated and Formerly Incarcerated Women and Girls.
Without objection.
This is also a statement opposing. It is from the Families Against Mandatory Minimums.
Without objection.
Another one opposing from the Federal Public and Community Defenders Legislative Committee.
Without objection.
And finally, another one from the Sentencing Project.
Without objection.
Thank you.
Question occurs on the amendment offered by the gentlelady from Texas. All those in favor say aye. Those opposed, no. No. Opinion of the chair, the noes have it. The amendment is not agreed to.
I'd ask for a recorded vote.
Recorded vote being requested. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Grothman? Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgardner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Ms. Crockett votes aye. Mr. Nadler, you're not recorded. Mr. Nadler votes aye. Mr. Grothman votes no. Mr. Moore votes no.
How's Massey recorded?
Mr. Massey recorded as a no.
Massey votes yes.
Mr. Massey votes yes.
Clerk report.
Mr. Chairman, there are 9 ayes and 13 noes.
The amendment is not agreed to. Question now occurs on the amendment in the nature of a substitute offered by the gentleman from North Carolina. All those, this will be followed by a vote on the.
Chairman, before we get to the vote, I'd just like to introduce a unanimous consent request.
Gentlemen can
Thank
say
you
his
very much.
request.
Sorry for the delay. I just want to introduce a CNN article entitled "Historical Loss: Alleged Gang Leader Evades U.S. Justice with Deportation to El Salvador."
Always eager to put a CNN article into the record. Thank you.
Well, we could do a Daily Caller if you'd like.
Some way. Well said. Question is on the adoption of the amendment of nature of substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
Opinion of the chair, the ayes have it, and the amendment in the nature of substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
The ayes have it.
Mr. Chair, can we get a recorded vote?
Recorded vote being requested. I thought that might happen. Clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Issa votes yes. Mr. Biggs? Mr. Biggs votes yes. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Hageman votes yes. Ms. Lee? Ms. Lee votes yes. Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Grothman? Mr. Grothman votes yes. Mr. Knott? Mr. Knott votes yes. Mr. Harris? Mr. Harris votes yes. Mr. Onder? Mr. Onder votes yes. Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes no. Ms. Crockett? Ms. Crockett votes no. Mr. Van Drew, you're not recorded.
No.
Mr. Van Drew votes yes.
Clerk will report.
Mr. Chairman, there are 14 ayes and 10 noes.
The bill is adopted. The bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment, the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. I know we had 2 other bills on the calendar. We're unfortunately not going to be able to get to those today. I have to get to a meeting here relatively shortly. That may take a while. So we will take up those other 2 bills at one of our next markup. The committee is adjourned.